Date was fixed to fix.
Why the lawyers' mics are not working? But sir,
Increase the volume.
why
My
lawyers'
volume
mics
of-
are not working? They are working. You are working. Yes. Kindly be loud. Day after.
You have filed contempt.
No.
Other side.
Other side has filed
I
contempt.
am confused. University.
Day after.
May I, sir?
But you mentioned in the memo that the earlier order
Yes,
signed date. So
already-
that they will know because they cannot know.
Already mentioned.
Yes.
My
Why when memos are accepted, why cases are not being
my lord
posted?
court's direction that judicial
No, not only this. We saw other case, some other case was mentioned before us. Even when we accepted memo, why cases are not posted? They have to come as they are. Even if there are office objections, along with office objections, they should come. That's the effect of memo. Suppose if some building is demolished,
May part of the my lord. This matter was listed before on 18/6.
what you want? Posting.
Posting.
When do you?
My lord, tomorrow.
Third week of July.
My lord, this is modification of order. Let it come tomorrow.
Your opponent in that matter?
Yes.
No. Now what do you want?
This order is from modification of order. The husband is got retired on 30 June
Modification
2005.
of order passed by this bench or which bench?
This week.
It's by this.
Yes.
So by modification, what is the urgency?
Urgency, sir, is the husband is directed in the Lordship Court has directed to in 19 June 2025 to give maintenance 40,000 per month. But the Lordship Court has directed to not to use her retirement benefit. So this maybe
So unless you pay, you will not get it.
No.
That you inform the other side.
no. The Lordship had directed on 19 June that I cannot
You
use.
don't have to explain again. Even if you are not telling the entire thing, still we can understand. It is a conditional order. If you do not pay, your retirement dues shall not be released.
And
So you pay it and
but the court is but the Lordship has also directed that the in maintenance proceeding I have to pay 40,000 per month. If I cannot get that amount, withdraw my amount from my account, how can I give the maintenance?
There's no restriction. There's no restriction on your part to withdraw to satisfy the decree. Anyway, when do you want?
Modification of this order
When do you?
When do you want?
for tomorrow.
Tomorrow it's not possible. And you inform the other side, file a memo with signature of your learned counterparty.
No, thank you. Yeah.
पूरी डेट कर दियो तो देखो ना रेट ऑफ पे 4th और 11th 11th पड़ेगा yes madam
Put July here.
अच्छा
Second time. Yes, again,
yesterday even telling you are not changing it
change.
rate of no sorry it's 11
11 years. Post on 14. Yes.
My lord, retopping, there is specific order to list on 15th May. So that was put in there.
Take that. Put it week of August. Some date of 2 week of 2 weeks to do. Yes.
Any date, my lord.
Any day.
Sorry.
First week of August.
Yes.
Take that. First week.
One rate of state file rate of case admission. Next week, your lordship will put it. Next week, when urgent matter, the opposite party is not getting pension, though the retired since long. And the order of the honorable signatures there.
sorry 12th is
Problem.
ଆଗ ଘଣ୍ଟାଟା କାଢନ୍ତୁ ଘଣ୍ଟା ପକେଇଦେବେ
That's some kind of
Lordship kind of keep the date next week.
In 1st August, we'll have the first week of August.
Your Lordship, any day in July.
That's what. The first week of August.
Obliged.
We have to take matters which are in the queue. We can't jump the queue. Yes.
This sudden anxiety, you have to be a little bit patient with us also. We have our limitations. How many matters we can take? All our hearing matters.
And family matters.
Family matters.
Causes, where we spend a lot of time in talking because it is necessary. Yes.
That individual to make a mention on behalf of the state. But at that day before yesterday on 30th, that amount imposition for that condonation of delay of 5,000. In fact, so far the Supreme Court order is concerned, that is clarified. My lords has also said.
No, we have not clarified. In fact, Samal Saab said it appears to be that way after reading that. But anyway, if you make an application, we'll consider. Not otherwise.
File an
It's an order.
It's an order for that. Judicial order.
I'll file an appeal.
And
Item 5. 11. Item 5.
You have to wait. 1 to 10, no mentioning. Yes. Basically, we are against adjournment first. Very reluctantly we consider. Yes. Want to discourage adjournment. Yes.
4, 15, 19, 5, 20, 24.
6.
26, 25.
Item 27, my lord.
27.
In last occasion, this honorable court has directed to file the liability assets affidavit.
When it was ordered.
Last occasion, I think of confirming that.
you have to say, sir, you are the conducting counsel. To that extent, we have to assist you.
Will you not make notes on your case paper? Which case was posted? Which judge? What order was
The
passed?
contracting counsel has been going to village for his daughter's marriage. That is why I am mentioning.
No, that's all right. But what about the lawyer who will write all these things? Nobody reads a lawyer's manual.
ମଝିରେ ବାହାଘର ତିଥି ସରିଗଲାଣି
ଆଜି ଅଛି ପୁଣି କାଲି ବି ଅଛି ଆହୁରି
ଆଜି କଥା କହୁଛନ୍ତି ତ ତାହେଲେ ଠିକ ଅଛି
When that order was made, just show that when that order was made. When one order is made, if you do not comply, we impose cost and do it. You can't ask the wife to sit, wait. Let us see. One it was. No, we'll begin with new culture now. We cannot go on wasting time of the court that way.
what was there to be complied on your part Lordship is asking you but your problem is that you do not know anything you are pleading
The appeal is only involving to the question of permanent only. Both the parties are directly filed as. This was 34/20/25. 36 is over. And court order is not complied with. You are appellant.
I am not opposite party.
Opposite party means appellant. No, respondent. Respondent. Both were directed to post it, na? File the affidavit.
who is for the appellant so you don't even inform wait sir you wait,
Wait,
let it
let us
you are
wait.
spending time without doing anything then or you inform any of your colleagues suppose anyone is not appearing and doesn't know what is the contents of the file you inform your colleagues.
Let us see. Yes, next. Act of will not be that way. Will not be right.
Item number 4. Not that. Item number 4.
So wait.
Let us start with one.
Wait.
There's 7.
Item number 32 by in this case, 32 by.
What was the
In
order?
this case, I am appearing for the wife appellant. My lord and friend is appearing for the husband, my lord. Respondent. Talk of compromise is going on, my lord.
Thoughts for Gongo? When it will be concluded? When they will be concluded?
10 days or 12 days.
Both the sides submit that the compromise talks are halfway through and therefore short accommodation be granted. First, we agree. Call this matter on which date? That date finally. We'll not waste our time. Huh?
After 2 weeks, any date as you
You said that. Choose a date from the calendar. 16. 16. All right. Finally. Final. The next prayer for adjournment shall not be entertained. Yes. 23rd, you can take that. We are giving more time. Okay, you come out with some settlement. Okay.
Item number 39.
39.
I am the appellant.
What is that 27/5/25 order?
But I am to get instruction on this matter. I have got the instruction.
You have got the instructions.
Yes, ma'am.
Then be ready and argue. Wait. We discourage adjournment. You have seen what Honorable Your Excellency the President has said of this country on 3rd of September. Courts are lavishly granting adjournments and they should stop it. That's what the President of this country said. Therefore, we have to be little punctual in our work. We can't work. This is not adjournment business. We are against that. Just kindly read now. Sit and read. There is a lot of time. Yes. They will not read. They will not come. They come to the court as if they are coming to. We cannot start reading.
Item 1.
Please, Your Lordship.
Yes, sir.
Lord, this is a matter of seizure of vehicle on the Forest Act.
Forest Act.
Yes,
Release of vehicle.
yes, ma'am.
Seizure of vehicle.
Seizure of vehicle.
You suffered order at the hands of the learned single judge now.
Yes, please.
Why he did not grant relief to you? What is fault with that order?
What might not be, he has not gone into the details of the legal provisions.
All right. Under which section of Forest Act vehicle is seized?
On the 56th.
Read.
The single. This is the dedicated jurisdiction of the single. Middle square versus number. Take up 5, 66, page 1. Middle square versus. It's not maintained. Important nourishment. This code, Supreme other benches by the
discharge in FO.
UD case.
UD case converted to work case.
Sorry.
Converted to work case.
Whatever, UD case, OR case adjudication went in against you. You challenge that in Father to Legend order before the decision. District order 227 High Court only way district order could be challenged to.
Then no argument against you. Okay. This intra-court appeal against learning single judges order dated rendered incomplete so as suffered by the appellant hearing does not like in as much as the first order was passed by the authority designated under which section of the Act?
56.
56 of
Forest Act of 1972.
No. My lord, this is the procedure. 56 is the seizure procedure.
Of which Act?
Forest Act.
under the provisions of Forest Act
1972.
1972. First, thereafter, matter was carried in appeal before the CBA district judge. And the appellant was proved. First, order of the district judge was carried, was put in challenge before the learned single judge. And apparently, it is under Article 227. Other companion Article 226 being an ornamental piece in the pleadings. But a single judge affirmed orders of the district judge who had affirmed the order of the authority designator. First, next time. It has been a settled position of law since at least half a century that an intra-court appeal of the kind does not lie unless the state legislation provides otherwise. Why? Despite turning the pages, the counsel appearing for the appellant is not in a position to notify to us the right of appeal arising under any state enact. First, it hardly needs to be stated that the jurisdiction exercised by the learned single judge was supervisory and very in terms of Article 227. First, next, in the most circumstances, the notice of appeal is this is what's been made easy. First, liberty is reserved to the appellant to take up appropriate proceedings for laying a challenge to have the grievance expressed elsewhere in accordance with.
Our own High Court decision is also there.
This is so.
Recently also in our own High Court, it has been decided. This is Navakumar Ratha versus State of Orissa.
Give me citation. No citation. Yeah.
This is also in the Supreme Court 2010, my lord.
Is it not reported?
It is not yet reported. ILR Part 1, my lord. ILR Part 1.
Just punishment.
I will punish.
Yes, punishment.
In this case, my application for NOC for running a BSc nursing course in my college has been rejected. And the rejection order, if your lordship would see, I'll just point out two things first, then I'll come back to the sequence of events.
Yeah.
If your lordship would come to the rejection order, which is at page 76 of the reclamation.
This is an exact.
Annexure 13. It starts from 75, but then I have left out the other pages without making it bulky. So at serial 119, mid of that page, if you know.
Serial number 11.
119.
That's nice.
At page 76.
76. Yes. 2515338.
Right. And on the right side is the remarks column, if your lordship please. Fire safety certificate from inform me from DFO not submitted. First. Second is institution building is under construction as per geotagged photo submitted by the institution. So if your lordship should see the letter by which I submitted this is at annexure 11, if your lordship should come to page 64. This is, my lords, dated 4/6/2025. Recent. The new institute.
Your letter is 25 February.
25 February. In this, I sent two things, my lord, if your lordship should see. Where the underlining is given in bold in the second paragraph.
Certificate and
Both. They say from the photograph in that communication or while rejecting that the photographs shows that it is under construction. But they say that they have not received this fire safety certificate. They say one. Yes, my lord. That I have submitted. If your lordship should see, which is yes, my lords. That is at page 71.
Like yesterday, the report incident, that industrial establishment, nothing.
Yes.
Fire safety has become such an issue.
No.
it takes it serious. Nobody takes it.
No, my lord. DFO.
From the days of Lanka Dhan, nobody takes fire serious.
Today, Lanka was
The DFO certificate, if your lordship should see at page 71.
It's 71.
Yes, ma'am.
and the building is definitely not complete.
No, my lord. This is a new building. No, my lord. The inside pictures.
Side is conspicuously not shown in the order.
No, my lord. They made the inspection. At the time of inspection, they never raised this issue.
Printing, not saying printing.
Yes, my lord. Because this is a new institute. This is the first year. The expansion thing is also to be there. Yes, my lords. Page 70. Then 7.1 is the fire certificate.
Just the road. We're not watching, we're not scrolling. How many years like this?
No. Whether in Orissa, and various other states, whether there is a suspicion certificate of the study, what your building or civil rights, it must be.
No, because that is it is not under the development authority. These educational institutions.
The municipal
Even then, also municipal, my lord, unless it's a municipal area,
will not apply.
it will not apply. It will be under the block where the later on the panchayats. So-
Some regulations.
Building completion certificate has been given.
Even
Yes, madam. So far as the present requirement of the course is concerned,
you may want is another thing.
is another thing. What is the basic requirement? Yes, for the first year for the course with the number of seats that is allotted.
And therefore, number of classrooms and other facilities.
Yes.
That's not the course you may put.
Later on, then expansion and then enhancement of the
Correct.
seats and everything.
72 deputy fire chief. Next page. 70.
And page 71, if your lordship should see.
Who signed me?
Deputy fire chief.
Is he competent authority?
Yes, ma'am, should be.
Then in that case, it's explained out. Who is your opponent?
My lord.
Lord,
You are the opponent. Okay.
My lord,
and just one second, not subject to lordship's
Yes,
consent.
Yeah.
In the order, because I try to point out, one part they say they have received those photographs which I sent along with the same letter. But they say that they have not received the fire certificate, which I sent together. The very
Even now we
discrepancy.
can show it.
Yes.
Do you have certificates and other things?
Yes,
You have produced?
I've given.
Give
I've
it.
filed.
Let us see.
I have filed. I have that.
I have received the copy yesterday, my lord.
Yesterday.
I have gone through the records.
When do you want?
One week.
Very simple.
Yes, my lord.
Whether structure is complete,
Yes.
so far as infrastructure is
Yes, my
concerned. Whether fire certificate is there.
Yes.
These are all 1 minute cases.
Yes, that I will do 1 week, man.
1 week.
Yes, next week.
Any problem, any interim relief you have sought?
No, my lord, the last date of admission is in September.
September.
So
Therefore-
1 week, I don't think any.
And I may come with positive instruction.
Yes,
That
I
don't
will
stay
get
in the context.
I will get the details
Otherwise, we will appoint a commission from the bar of 2 persons, coupled with the engineer of our High Court. He will go look into and come here. These things, why authorities do, we will not spell out.
Yes.
Now, now we will not say anything.
So, my lord, I will give the details.
No, not the
Question is
You can't
simple.
supplement now, Mr. Masti. You confine to your reason.
Yes, my lord, that I will.
Govindas Bhanji and
We will send some college authority
we have also Lordship has pronounced judgment.
that to 1952 Supreme Court, page 16. Yes. Therefore, warn your officers. They will not be just putting something on the paper and go away. They will go, but not away to some other place. Yes, we know what is happening in these things. Yes. Learned senior advocate appearing for the petitioner institution points out that his client had sent the fire certificate, fire safety certificate,
along with
the geotag
photographs of
the structure of the institution. First off, he asserts repeatedly that the structure, so far as infrastructural requirement is complete, and the fire certificate is competent. First, a prima facie case is made out for admission, and therefore issue notice to the opposite parties. First of all, learned panel counsel Shri so and so accepts notice for 2 and 3. 2 and 3. One is for who? State.
One is for the state government.
State is
the fire safety issue is there, that is issued by the state government.
Mr. Mishra,
And also the
learned AGA, on request accepts notice for first respondent.
District fire officer is not made a
No.
State.
I'm sorry.
State.
No, district fire because he has already issued. No, the government has to, only verification has to be done by the
Certificate.
Family and Welfare Department, Health and Family Welfare.
But in
because
such
it's a nursing course.
But generally, in such circumstance, the persona designator should be the respondent, because we can ascertain from him
He will simply say that
whether you have issued, not issued.
No,
All
the
these
lordships
things.
can say we will add.
No, not necessarily. Now state is there.
right now,
Now state is
they
there.
are not disputing
Next
about
matter. Very, very clear submissions we have understood. Very few people make this submission this way.
Deputy fire officer may be the authorized author.
Yes, you have to show that also.
Yes, that also.
So in all places, it is not required that the district fire officer and it's a remote area, Nandahandi.
It's a DFO. DFO is necessary.
District forest officer.
Yes.
Let us see. Let us see.
District fire.
Not a necessary party.
Deputy fire
Because
officer.
his action is not challenged.
Yes, it's not well.
In which famous judgment that Rajia Begum versus some another 58 Supreme Court says who is necessary party, who is not necessary party. If his action is not challenged or his presence is not otherwise required, he is not a necessary party. Yes.
During pendency of the appeal document, the sole appeal and namely Ramori Senapati died on 2/12/2024, leaving behind him his legal heirs as who needs to be substituted to their legal heirs. And I filed this case, so Lordship, notice will be issued to other opposite parties.
Issue emergency notice to the LRs of
Sole appellant and Ramori.
LRs of DC the sole appellant or appellant respondent.
Appellant, sole appellant.
Appellant, why notice?
Notice to whom?
Why notice?
No, in respect of your Lordship appeal. After
Appellant is dead.
being allowed, your Lordship.
Appellant is dead. Appellant is dead. Respondent.
Sole appellant is dead.
Correct.
I filed my Bakalatnama with the
Application.
legal heirs who has given power to me.
Correct.
Thereafter, Lordship, notice, appeal notice is necessary to be sent to the respondent.
Respondent, okay. That application is to be allowed. No.
This
So
is within time.
Sole appellant having died on 2/12/2024, an application is moved supported by an affidavit to bring his LRs. His or her. You don't write Srimati, Sri, nothing.
Your Lordship, wife, one daughter and son.
No, who died?
Appellant is male person.
He is what? The sole appellant having died on 2/12/2024, an application supported by affidavit is filed.
Because this is not
The lead application was dismissed for default on wrong application of fact that the
Actually, number 1 in detective is 164. We can recall the name. Are you aware, sir? You are the counsel who was at
yes, Your Lordship, I was the counselor.
when the detective was dismissed, when which order?
No, all this, Your Lordship, that has been restored to Your Lordship.
When sir, by which order? That also have to say.
Your Lordship.
When it restored. Which order?
Both the, Your Lordship, two same appeals have been filed.
Sir, those
Have been restored to Your Lordship.
there are only 2 orders in my record. In fact, I can also. That is now it becomes so incorrect. Find the order when it is restored.
No, Your Lordship, I will check up. It has,
Sir, when you will check up the file before you sir.
I think.
Other things are become easy. It's available. Look at the file.
Latest argument.
We spent so much time to decide when matter was.
Because our order today will be again wrong. You must understand that.
No.
But dictating will be wrong if I do not follow the earlier order. Sir, don't look at me, look at me. If by which order it was restored.
When Passover just looking to it, that makes it. Passover.
Yes.
11.
Yes, please. By state.
Yes, my lord, the intra-court appeal by the state and all the similar matters. Other analogous matters are there, my lord, 5 matters. 5 matters are there along with exactly. This is a
5 minutes, that's delay.
delay, my lord.
How many days?
No, second item, it is 166 days, you know.
66 days.
Days.
Lordship, I am appearing in the lead matter matters. There is 654 days delay in 684 days in the first item, my lords. Writ appeal 1323 of 2023, lordships. And my lords, in writ appeal 814, lordship, last item.
In the first appeal, how many days delay?
684.
684. Application is filed.
Yes, application is filed. COVID period was there. So 90 days relaxation is there by
Subsequent
virtue of the
COVID
announcement. Appeals court then
684 days. COVID came to an end with the notification of the government.
government.
When it came to an end? COVID-19.
In
25/3/2020 it began. And it came to an end on
28 February 2022.
28 February 2022. Then also it is beyond that.
And this was filed in 19th June 2023.
When the order was made, impugned order was made on
Informed order was made on 25/2/2022.
25/2/2022.
No.
22.
Well, in this writ appeal 1323, the order was passed on 4th.
We are asking serial number one, na? Now we are holding the papers of serial number 1
Yes, correct.
in that
Well, it's-
batch.
It was,
That
order
was
was
this-
passed on 4th August 2021.
Not so far. First 1323 is concerned.
New papers. What option?
Judgment is 4/8/2021.
4821 is within limitation. Within limitation. February 22 is revocation of order.
20.
Revocation order.
28 February.
You are taking up writ appeal number 1323 of 2023.
23. The first item.
And the appeal was filed on 19th June 2023.
One second. Impugned order is dated
4th August
2021.
so during COVID period
Yes, ma'am.
of it. COVID ended on 18 February, 22 February,
28
28 February, 22.
as per the judgment of honorable appeal.
Yes. When appeal is filed,
This is my lord 19/6/2023.
nineteen 6/23, and your explanation for the delay.
And then one is
This will be how many days delay?
This than 635, 653.
653 days delay.
This will be around 485.
For 85 days.
So February to February, March to March is 365 days, roughly. April, May, June. April, May, June, 15 days.
May,
So
June.
75 days,
Around 15 days.
So 440 days. 440.
Roughly 440.
About 440 days.
Roughly 400.
What is the explanation?
Well, rest of the expansion is regarding communication and
Now, if you say that way, what is that? Every case on delay, you always individually to be treated. Of course, we have seen that writ appeal where court said it's an individual case. Court did not say in all state appeal, condone the delay, take the matter as if there is no limitation period for the state. We can't read the judgment of the court like Euclid's theorem. It is confined to the facts of the case.
well, para 4 and 5 I have taken the averments.
Read.
But after that COVID period, that after the aforesaid, the government in the Health and Family Welfare Department submitted the proposal to the Advocate General.
When it was submitted?
It is my lord 6/6/2023.
Till then, what happened? 6/6. See, it was decided on 4/2021 and we were entitled to sleep over the matter till 28/2/2022 because it is COVID. All right, we will believe that way.
1/3/2021.
When it got up from the slumber, the government has to get up from the slumber, at least after the COVID is over. When it woke up, and orders on condonation of delay are not orders in rem. They do not lay down law unless propositions are stated. So it all depends upon individual cases. Otherwise, it shall be a death knell of law relating to limitation. Law relating to limitation does not say State Limitation Act is not applicable to the state.
No, that is not.
Is it not? It applies to you as it applies to Tom, Dick, and Harry who comes before the court. Now, when you say on 6/6/2022, 23,
23 minutes.
6/6/2023, that is after 1 year, almost 4 months.
3 months.
3 months. What happened in that period? We'll assume that this matter was decided in March 2022 for all practical purposes. Where is the explanation?
No, only government after the.
No, where is the explanation for 1 year, 3 months?
Only and exception.
Every day has to be explained, not hourly basis. But the apex court said almost every day has to be explained, saying that during that period, many people had died because of COVID. We were taking action. We were going to burial ground, something like that. Where is that? Saying that Advocate General spoke to Minister, Minister spoke to Secretary, Secretary spoke to Deputy Secretary, Deputy Secretary spoke to Under Secretary. That is not an explanation.
So far the delay in the part of the government, so far the procedural part is concerned. When this office has received on 6/6, immediately it has been filed on 9.
No, we are asking what happened from both 8/21 to 28 to February. We understand. From March 2022.
After the COVID period, Marat knows the rehabilitation, resettlement.
Where have you stated? Where have you stated?
And this is general ground.
No, general ground cannot be.
That is
we can't depend upon your personal knowledge.
Marat knows the predicament of the government.
No, we do not know. We think the government is very efficient. Therefore, we have elected people there. Where is the explanation? You can't say that this happened, that happened, cock and bull story. That is no ground at all. Government has to, ours is a welfare state, very vigilant, vibrant state. Some advertisement I saw of your government of Odisha, by vibrant government. Big advertisement was there in the airport when I landed there. Where is vibrancy? All contentions are kept open. On consideration orders also you appeal.
Yes, this same order has been confirmed by the Supreme Court twice, Lordships.
Which
order? Is order under challenge.
This order is confirmed by the apex court.
Similar matters, similar posts, similar issue, the pharmacist, same circulars. This has traveled to Supreme Court, my lords, and in April 16, 2024, my lords, the second order of dismissal also has come from Supreme Court. The state had preferred. First in 21, Amit Mishra, which is cited in this single judge order, and subsequently, same thing
is followed by the learned single judge.
Yes, it should be considered in the terms of Amit Mishra.
Amit Mishra. So far the merit of the case is concerned, my lord. So far the impugned order, which is at Annexure 2 in the second part, my lord. That is only it has been at the stage of admission, this has been disposed of keeping in view that Amit Mishra.
Correct.
Yes, which has been subsequently confirmed by the Honorable Apex Court. At that particular time, the rules which is governing in the field, this has been repealed, well, that has not been taken care of. That is
consider and state in your consideration.
Not only that. We'll assume that, number one. Number two, we'll assume that the law is repealed. The rights, see section 6 of the General Clauses Act. Read section 6. General Clauses Act 1897. Somebody told me that your state has adopted it. You only told that other day.
Yes.
So kindly come to section 6 of the General Clauses Act. The rights and obligations accruing any law would continue, notwithstanding the repeal.
But my lord, so far my humble submission would be,
yes,
kind of a glance to the impugned order.
One second. According to you, what are the faults? So on delay, you have no more thing more to say. Understood. And you bank upon that apex court decision also.
Yes, ma'am.
All right. Which is that case?
May I pray for to follow the second writ application?
Second one.
Second one. Sub item. I can say it sub item.
Sub item 2.
Sub item
1201.
The number is 1201.
1201 of
2020.
2020.
202.
Sorry, 2022.
22. Yes, sir. When the order was made?
This is on 25/2/2022. It is at relevant page is page 26.
Page 26.
Exactly.
What is the delay here?
This is by the.
Is there any by
No. This is by the petitioner, the respondent concerned.
Respect. Okay, 169.
Because it was filed before the state administrative tribunal after abolition, then referred to this Hon'Ble court.
So he is in appeal.
Is an writ, my lord. It is a transfer from the SAT to High Court because after the abolition of the state administrative tribunal.
In our state, there is no administrative tribunal now.
That has been
Abolished.
Yes.
Okay.
Since 18.
Which judgment you want us to read?
My lord, page is base 26.
Page 26. What is this advertisement?
25.
To the very same posts
Yes.
which they were seeking regularization of?
No, madam.
No.
This is made for 4 pharmacists of a particular category. These persons have been appointed under the Mobile Health Unit, MHU.
Kindly come to paragraph 4.
Yes, ma'am. Learned counsel for the petitioner, ma'am. Contended that in a similar matter, that is OS 744 of 2017, the Odisha Administrative Tribunal dated 17/5/2018 has quashed the similar notification by the CDMO Bolangir and directed the applicant therein brought over to the contractual pharmacist under the General Health Stream (DDC) without facing further recruitment test as advertised issues, as they have already completed 6 years of contractual service in Mobile Health Unit (MHU), and the said service be completed.
Said exercise be completed
within 1 month from the date of receipt of this copy of the order. Against the said order, the tribunal, the state preferred WPC number 395.
And that was dismissed on 21/11/2019.
21/11/2019.
Yes.
Confirming the order of the tribunal. As the said order was not implemented, again WPC number 1355/2020 was filed, and the said petition was disposed of on 3/2/2020.
Asking them to go before the tribunal. They went to the tribunal in 2018.
Yes, ma'am.
Then,
and opposite parties to work out the direction of the tribunal contended in order in 2018, passed in OL number 744 of 2017, challenging the said order, state before the SLP.
And that is dismissed.
That is dismissed. But I am coming to the
SLP against the High Court order or the original order? Confirming.
This High Court order.
High Court order. See, there are 2 High Court orders.
Yes, ma'am.
One is on merit. One is simple that you compliance tribunal order.
Compliance tribunal.
So which you are challenged in Supreme Court?
25/2/2022, which I am ready to.
Tribunal's order remained intact.
Intact.
That treat you have, that tribunal's order, have you challenged in Supreme Court?
Yes, madam.
That it's not apparent from that.
Kind of also page 57, madam. That is the order of the honorable.
No.
What was challenged before the in
SLP petition? Which order was challenged?
There are 2
You don't have to show any page.
744 of 2017. 744.
No. That is a way order.
That is the way order.
There are 2 writ petitions.
Yes, ma'am.
One is WPC 1353. Order dated 3/2/2020.
May This is a copy I'll handle.
So 1353 was challenged.
Yes, no, 1350.
50.
1350 is one which arose from the tribunal.
Sorry, one piece actually, man. Yes, that much.
What you say is correct.
1350.
Mr. Bhanti, the other writ petition is 3957 of 19. First one is 3957 19. Second one is 1353 of 2020.
1353 about 2020.
This is 1353 of 2020.
Disposed of on 3/2/2022. But therein, it was directed to work out the order which has been passed in that omit.
That was in writ petition.
This was challenged.
That was in second writ petition.
Second writ petition. Second writ petition, this was disposed of keeping in view the order of the earlier one, Milord.
Correct.
That is 744 of 2017, Milord.
Correct.
Which has been passed by the Honorable Tribunal.
Right.
That order was challenged. Kind of a glance to page, the order of the Honorable Apex Court at page 57, Milord.
That order was challenged means High Court order was challenged.
Yes, ma'am.
Because you said OA was transferred back to the High Court. So a single judge passed the order.
Passed the order.
Single judge or division bench?
Single bench, ma'am.
Single bench.
Confirming the order of the learned tribunal.
That conferring means following that order of the tribunal. OA number
OA number 744
of 2017.
2017.
What is that OA number?
744 of 2000.
OA number matter 744 of 2017. Basing upon which
Just you have to go slow.
Decided in 2018. Which date?
21/11/2009.
17/5/2008.
75/80.
What it said? Consider. Was it a positive mandate or mandate for consider? Order to pass order.
Pass the order, Milord.
That's all.
Yes.
All contentions were kept open. And that order attained finality.
Yes.
No challenge was laid to this order.
This order was challenged.
In the first WP.
First of all.
WP number?
3957 of 19.
3957 of 2019.
19, my lord. And it was dismissed on 21/11/2019.
Matter was taken in SLP.
No matter. After that writ application 1353 of 2020 was filed for non-implementation of that order.
There is no contempt jurisdiction.
Since the tribunal was.
Since tribunal was not functioning. Okay, you are right.
This was
lie before the single judge here.
Yeah.
This was disposed of on 3/2/2020.
That WP
1353
of 2000.
2020.
Single judge did not implement the order.
Directed for implementation.
Directed for implementation.
3/2/2020.
The order which has been confirmed.
Where is that order? Where is that order?
3/2/2020.
3/2/2020. Can I read operative portion of the order? Just read operative portion.
Only order dated 3/2/20. Serious allegation has been made by the petitioner that in spite of relief granted by the tribunal in OA 744 of 2017 dated 7 by the Annex 2, and further this order being confirmed by this court in disposal of WPC number 3957 of 2019 dated 21/11/2019 by the annexure, the opposite parties are not working out the direction of the tribunal. Considering the allegation as a serious one, this court disposes the writ petition directing the opposite parties to work out the direction of the tribunal in OA number 744 of 2017, dated 17/5/2000, within a period of 6 weeks from the date of communication of this order, by the failing which so motor content proceeding will be drawn.
This was 3-20 was taken in appeal.
My lord.
That is Amit Mishra.
SLP.
Both put well, I have passed on that order. 135.
This order is not carried in.
My lord,
It has attained finality.
that order was challenged.
No. ODA 744 of 2017 is 17/5/2018. You laid a challenge to that in WP 3957 of 2019 that eventually came to be dismissed on 21 November
11, 2019.
2019.
So what happened thereafter?
Thereafter,
Thereafter, another writ application filed by the
no, that is, you did not challenge this. Order passed on 21/11/2019 attained finality, there being no further challenge to the same.
No.
Correct.
Consequential order.
Consequential order is second WP.
Second WBC.
Second
That is
WP.
under challenge so far this Honorable Apex Court is concerned. Has paid 57 men.
There's 57.
Yes, ma'am.
This order.
This order.
Same Amit Kumar.
Now, what the Apex Court said?
Well, therein, inviting my lord's attention
Not inclined to
internal
interfere.
phase 2. Internal phase 2.
Last line, not inclined to interfere.
But before that, can I read?
Yes.
On the other hand, we're at the top of the queue.
Let us see the first hand.
Page
now.
58.
We have heard letter concept plea of present concept of data is that 6 of.
We're looking at from the beginning. Look at
Yes, ma'am.
we have heard that.
We have heard learned counsel for the parties. The plea of the learned counsel for the petitioner is that in terms of Rule 6 of the Odisha Pharmacy Service Method Recruitment and Conditions of Service of 2015, the mode of selection prescribed for the pharmacist is through a process, selection process, and therefore pharmacist employed on the contractual basis under different scheme cannot be regularized. On the other hand, learned counsel of the respondent has drawn the attention of Rule 4 of the very rules, which provides for such contractual pharmacists to be observed once they have completed 6 years of satisfactory contractual service through a deeming provision. In fact, the pharmacists who are yet to complete 6 years for contractual service are to be deemed to be contractual government employees and would be regularized as the completed 6 years of satisfactory service as per the provision. In view of the aforesaid, there is a little doubt that as per the statutory rules framed by the state of Odisha themselves, they have provided for a deeming provision for such contractual employed pharmacist, and Rule 5 talks about the modalities for the induction of the pharmacist.
After 6 years.
Yes, ma'am.
Then nothing.
While they are considering this case.
You said to the Apex Court,
Yes.
rules provide for screening.
Still.
Court did not agree. If screening was intended, the rule maker would have made a provision to that effect.
But the minimum educational qualification as per the new rules came into force. So that has been prescribed under Rule 4, 5 and 10.
Rule 4, 5 and 10.
Yes.
So Maharshi, just kindly just read slowly. Missed one line. Their induction. Please read it slowly. Their induction, the last three lines is to be based on a minimal educational qualification and other eligibility criteria.
Right.
As per Rule 10, and it is nobody's case that the respondent do not meet this requirement.
Made this requirement.
So if you say before Supreme Court that they meet the requirement,
How can you discriminate against these people?
My lord, this has not been discussed. But while
you are in review of the Supreme Court judgment.
no, ma'am.
Not been discussed. What is
Nobody's case for the respondent who do not meet this requirement.
Correct.
So
They
there
are identically placed. What was their qualification?
Their qualification was not as per the rules.
Then this contention is not agreed.
Amit Mishra was qualified, you are saying. Amit Mishra was qualified, they are not they are not qualified.
While Amit Mishra's case was disposed of, by then this rule was not framed.
So then you have to pass that order. You are prejudging it then. Suppose you are complying the High Court order. You are saying that Amit Mishra was qualified as per the rules. So and so XYZ are not qualified as per the High Court rules. I think so that.
No,
because Amit Mishra, they say that
in Amit Mishra, what was the qualification of Amit Mishra?
Qualification is, my lord, so far this
Same.
rule is concerned, my lord. May I submit, my lord, that advertisement?
Simply say, so that it
May I
because
say-
we are
An
here and there, you are.
My lord, qualification is, I am ready.
Amit Mishra, find out.
Must have passed +2 science examination under the Council of Higher Secondary Education,
This rule came into force when this is amendment.
2019.
So this is Amit Mishra.
2019, huh?
Amit Mishra is prior to.
It is prior to,
No, their appointment is prior to or before amendment or subsequent to amendment.
this is
2008.
prior to.
Ah, if it is prior to,
Amit Mishra is concerned, it is prior.
no.
I was appointed.
Even they were appointed prior to amendment.
Yes, yes.
How can you describe, how can you apply that rule to an event which has already happened? They had gained entry already. As of the date, what was the rule?
That was
That was the rule. So Amit Mishra, they stand on par with Amit Mishra in all fours.
So far this appointment is concerned initially, at that point of time, there was no rule. Subsequently, in 2015, my lord, this Odisha pharmacy.
No, by 2013 there were rules already. Already there were rules. Otherwise, Amit Mishra case would not have arisen at all. Logically, Amit Mishra case would not have arisen. But because you pressed into service the particular.
And all the rate applications has been disposed of basing upon the Amit Mishra's case.
Correct. You need to say that every individual case should be treated. What applies to goose will apply to gander. Why individually we should treat? But if case fact matrix is matchable, then what relief we have given to one set of people, we cannot deny it to other set when they are completely similarly circumstanced. We need not take every mango and see, taste it, and then give it back to people. That's what only Shabari would do it to Rama. We don't do it. Once, if there are cases, even Supreme Court has gone to the extent of saying, all need not come to court at all. Since all are coming to court, pendency has gone up. If similar cases are already decided by the court, the government being the model employer should extend similar benefits to the citizens. At least 3 judgments are there.
And just look at the opening 3 lines of Supreme Court judgment in Amit Mishra, State versus Amit Mishra.
Yes, ma'am. Page 57.
Whatever. And
That
then
judgment.
The plea of learned counsel for the petitioner is that in terms of Rule 6 of Odisha Pharmacist Service, methods of recruitment, conditions of service rules, the mode of selection prescribed for pharmacist is through a selection process.
That is negative.
Pharmacists employed on contractual basis under different schemes cannot be regularized.
That was your stand.
So, I mean, this selection process, what do you mean by that?
And
The earlier appointed pharmacists.
they are on a committee and for a particular scheme.
Qualification, sir, qualification. Now we have again, I mean, from the, whether it by selection process or by a committee selection.
Qualification
Suppose you are saying that Amit Mishra qualification and this person's qualifications are different.
are different.
That you are not very clear now. And Amit Mishra is, because you see, once Supreme Court gives that finding, above paragraph that
Last line.
last line,
3 lines.
3 lines. Rule 10. Rule 10 of that 15 rule.
Rule 10.
Redeeming
Mishra
point.
was qualified.
If Amit Mishra is qualified, this person cannot be said to be unqualified.
And that is not your stand also.
Because
you are not
Amit
yourselves are yet to consider and find something.
No, if all this has happened, if we send it back, again he will say the same reason and send them back to the court. Now battle lines are drawn up because he has argued the matter. We are giving you now, Mohanty, Mr. Mohanty.
Amit Mishra's now print into.
Sometimes that way happens. Now, prima facie, we are of the view, Amit Mishra and their case are on par with each other. Whatever way you have treated case of Amit Mishra, that way you have to treat their cases also. And we were thinking it's only an order to pass order, therefore we will not interfere in appeal. Even that will not be available to you. because now battle lines are drawn up. You have disclosed what you are going to do. Therefore, it amounts to an order in futility. If we pass order saying that you pass an order like this, you will say that they do not qualify because they lack the educational qualification and send them back. For that purpose, they don't come to court.
May I take the leave of this court? So far the qualification is concerned, may I take 7 days by that Amit Misra, and so far the other aspect is concerned,
No, where have you taken up the contention that these people do not have the qualification which Amit Mishra had? Had you taken up that contention, we would have given not 17 days we would have given to you.
We have all the way taken the ground so far the counter is concerned, Miller. That is also
Process. You are saying selection process. Supreme Court goes and says that
There is no
Mishra
selection process.
qualified. So your reliance on Amrit, I mean this because you challenge, you have obtained this order, state versus Amit Mishra.
State versus.
So that stares at you also.
And so far this second sub item is concerned.
And most likely for a sensitive post like pharmacist, substantial healthcare they manage. I think without selection process.
We are not starting on the OM.
No, they finally go to the Supreme Court judgment, last paragraph. The penultimate paragraph.
Yes, ma'am.
Learned counsel for the petitioners states that apparently the rules are not very happily worded. Most of the times they are not happily worded. Anyway, worded. And what was envisaged was that even the contractual pharmacists would have to go through an open selection process in view of Rule 5.2. If it was so, in our view, that the rule should have been so framed as Rule 4 introduces a deeming fiction for regular employees who have completed 6 years of service. For those who have completed 6 years of service, no more torture. By deeming of law, they come to a particular pedestal. Law can deem man to be woman and woman to be a man. Because that's the legislative prerogative. And that is the prerogative of the delegate of the legislature, rule-making authority.
Keeping in view Rule 5 Romanic 2, may I read that?
It is already interpreted by the Apex Court. You may read it, no problem. Read what Apex Court said on that.
Rule 5, my lord. May I read? Page 29. Modalities for induction of pharmacists into the cadre.
Correct.
All the contractual pharmacists who have completed 6 years of satisfactory contractual service under the society oblique scheme shall be deemed to have been inducted into the cadre subject to the following conditions.
Correct.
Condition number 1. Such pharmacists who have minimum educational qualification and other eligibility criteria as per the Rule 10.
At one day, it only reminds me of what Roosevelt used to say. In America, we have a constitution, written constitution. And that constitution is what Apex Court says. Similarly, you have rules now. Rules are interpreted by the Apex Court.
Yes.
That interpretation becomes part of rule. How courts interpret, to borrow words of Justice Holmes, what court is going to do with the rule, that is law, definition of law. Very criticizing Austinian definition of law. Holmes said this, law is the prophecies which a criminal sitting in the court hall will have about what the court is going to do. That is law. Now court has done. Apex court of the country has placed, after seeing those rules.
We'll bow down to my lords and as well as the order of the honorable.
You can't interpret the rule.
No.
Variance with the opinion of the highest court of the country.
I am not standing on the. So far, they would have to go through an open selection process in view of Rule 5 Romanic 2 minutes. Just that I am pressing more. I am no way I am interpreting more. So far, this selection is
rejected, Mr.
That we is rejected.
You in fact in the first when beforehand when my lord was looking and you were saying almost you considered that interpretation has been rejected in your appeal.
May I take the chance so far the
No, what appeal? Kindly read read that judgment, the last that paragraph, which I read loudly. You may also read it. Learned counsel for the petitioner states, petitioner was yourself.
Yes, yes.
Yes. Apparently, the rules are not very happily worded, and that was envisaged was, what was envisaged was that even the contractual pharmacists would go through an open selection process in view of Rule 5.2, which you read now.
Yes.
What Apex Court says is, this is important. If it was so, in our view, that the rule should have been so framed as Rule 4 introduces a deeming fiction. Apex Court did not agree with your interpretation, but deeming is there. Once deeming is there, after the happening of the event, namely, they have completed 6 years of service, they come to particular stage. As simple as by operation of law. Well, that's the deeming. Deeming is a fiction.
Yes.
There's one famous book on deeming, Law of Fiction by Raghavacharya, one of the famous books Indian author has written. That is deeming. And once it is deemed, it is not presumption. Understand this. In case of presumption, you can lead evidence to rebut the presumption. In case of a deeming, it is a conclusive proof. You can't lead evidence to rebut what is deemed by law. And therefore, you cannot argue against deeming also.
May I read Rule 4?
Rule 4.
2019. I have given that set of papers also with a green flag. 2019 Carter Rule. Rule 4 I am placing lots of.
Rule 4.
On the date of commencement.
Give him a copy also.
From the date of commencement. Of what? Amendment rules.
Of these rules.
Of these rules.
All the pharmacists who have been duly recruited by concerned society schemes have completed 6 years of satisfactory contractual service shall be deemed to be regular government employees as one-time measure subject to fulfillment eligibility criteria as prescribed under Rule 5. And he has been recruited in 2009. Before that also there is a rule of 2008 lordships.
4 makes you government employees by deeming process. And screening, etc. is for other people. Appears to be that. That's what the Apex Court has said.
In the same
One-time measures. So are
the same set of papers,
One-time measure.
One-time measures. Fulfillment of the eligibility criteria as prescribed.
One-time measure means what?
The person, those who are working under the mobile health unit,
all of them it applies.
in order to accommodate them.
completing 6 years.
The only condition is 6 years.
Yes.
Proviso is?
Proviso is so far the Rule 5 is concerned and 10 is concerned.
To complete 6 years of contract service.
And the education.
And he is a pharmacist admitted to minors. The education qualification. Rule 10 says minimum education qualification, the education qualification of a candidate for the post pharmacist shall be.
So as and when they see, the first section, Rule 4, Rule 4 contemplates a set of contractual employees who have completed the 6 years. Proviso to Rule 4 contemplates a set of complete contractual employees who have not yet completed. Correct?
Yes, sir.
And who will complete in future. They are also on such completion deemed to become the regular government employees. Proviso. Kindly see proviso. Proviso is generally read as an exception, but this is not an exception. It's a substantive rule itself.
Provided that all the contractual pharmacists.
And your clients are pharmacists. Okay.
Who are yet to complete 6 years of contractual service and having eligibility criteria as prescribed under Rule 5 shall deem to be contractual government employees as one-time measures and shall be regularized as and when they completed 6 years of satisfactory contractual service, including the service that they have already been rendered in concerned scheme or public society. Provided further that those contractual pharmacists who do not meet the eligibility criteria as mentioned under Rule 5 and shall continue as such under the State Health and Family Welfare till closure of the project, retirement or disengagement, whichever is earlier.
That is not your case, that they were all contractual on 8th March 2019. That is not an issue. Article from my lord, this provided. This proviso is the substantive part of the statute. It's not a proviso.
It is not a proviso.
The first part, the first paragraph.
That is the reason why counsel argued before the Supreme Court that they are not happily worded. That's right. Because Crawford on statutory construction, like GP Singh, all these are there now. They say proviso is to be interpreted as an exception to the main rule. But they give an exception to this rule, saying in sometimes because of the error of the draftsman, he calls the proviso. In fact, he should have called it as a subsection 2.
Like explanation.
Like
explanation we could have given.
It is not a proviso, not an exception. The word provided is used, the term provided is used. It is not an exception.
Only that.
According to you, does it help you?
No.
So far,
We are of the view that proviso doesn't help you as far as
Only
challenge
that-
to the order is concerned.
Rule 5 eligibility criteria is concerned. Only that point I can have.
That put a national, by the apex court itself.
One says that
That is process.
you open it. Maybe in future in Supreme Court.
Those were continuing without
the schedule there because that's not disputed even. Last page of
Rule
that.
10, my lord. Last page. my lord.
Last page, go to the schedule.
Yes, my lord. Sir. Pharmacist district cadre.
Yes.
We have must have
First plus two science.
science examination or council of secondary education or equivalent diploma in pharmacy from the government medical college and hospitals of the state. Any other
Just give us a moment. Give us a moment. That's it.
page, page 35 and 36.
That doesn't help you.
Then what is your case?
All the cases have been disposed of,
Correct.
keeping in view the decision of the Amit Mishra.
Correct.
By the time Amit Mishra
May I
was
show
disposed of,
last page of the booklet I have submitted.
Booklet.
Last page, yellow flag.
Well, we'll come to you. We don't want to disrupt him. Already we are falling on his head. Wait. He has an uphill task now. Will not pass any orders without hearing you. Kindly be seated. Brother, first your contention is their case is different from that of Amit Mishra. Correct? Just right now. Learned AGA submits as the first proposition that the learned single judge has grossly erred in following Amit Mishra case, since the respondents herein have a case in variance with that, in as much as they lack educational qualification, as prescribed under 5.2, Rule 5.2
of the
read which schedule? Rule 5.
Rule 10. Schedule. Schedule 1, Rule 10.
Schedule 1, Rule 10. Item 10. Item 10.
Schedule 1 is provided in Rule 10. Educational qualification is referred in Rule 10.
Read with Rule 10 and
Rule 5. Rule 10 read with Schedule 1.
number 1 is over now.
Oh.
The second proposition.
Second proposition is one. The appointment was issued to this respondent by virtue of the selection committee. That is a joint committee of the CSC in the mobile health unit, not by of an advertisement.
Not by, no, there was no advertisement.
Advertisement was lateral.
Subsequently, advertisement
Yes,
came.
ma'am.
When were they appointed?
They are in 2002.
2002.
Yes.
They have already put in 23 years of service. Have they put in 23 years of service?
Yes, ma'am.
As on this date? When you came to know their appointment is not proper?
When
So,
they are-
Auntie, you have to be very clear in your instruction. It's my perception that their selection and appointment was then as per the prevailing norms. That is how your rule doesn't make exception. your rule 2019 rules
19 rules.
doesn't make an exception regarding any selection method. Rather, it says whoever are continuing in contractual basis will be regularized.
Because there were no rules only, according to you.
You're right. It can be that they are not qualified. But that their appointment, initial appointment was as per the prevailing norms. Whatever is prevalent, that was done.
By the committee decision.
You can't say they were not qualified because there were no rules which prescribed qualification. Mr. Monti, is it your case that their appointment was non-liquid in the sense there were no normative rules at all? Is it your case?
Yes, ma'am.
If that is so, how can you say that they did not have requisite qualification?
But keeping in view the scheme of the central government and the state government and emergency recruitment, they have been selected by the committee to work in the mobile health unit, not in the CSC or PSC.
No, we are on qualification. You said we are in an extended arm of another your contention now, an offshoot of your contention. You said they lack qualification. Which qualification?
But prescribed in the Rule 5.
Rule 5 is it comes after 2019.
They are only
when they gained entry to your service.
Only pharmacist, you know. So far the other aspect is concerned.
They are pharmacists only.
They are pharmacists, but Rule 10 prescribed. I'll kind of a glance to the schedule, for a moment.
When they completed 6 years, which date? When did you complete 6 years?
My lord, in this case, they appointed in the year 2008 on contractual basis. And they are still continuing.
No.
On which date they complete?
2014 they have completed 6 years.
All they have completed in 2014 only.
No, Mr. Sahoo, his case 2002 is right. He's holding
Yes,
so why you are disturbing when he say he's right in 2002, not 2008.
I'm in
It is Prashant Kumar Behra.
Exactly.
So that is how you are in the first item. Name is something else. This 2002 I was when he started. My lord asked, I was checking.
In 2002 there were no rules.
No.
So everything was done in executive power.
Yes.
Correct? Then how can you say that he did not have the qualification based upon the rules that come into force after 17 years? Suppose if you make rules today under the proviso to 309, saying that all FDCs, they should have graduation. That would not apply to the FDCs who are already working in your department. Otherwise, all they have to be sent out. Unless the rule itself says all those FDCs who are working without this degree shall be sent home, then they can be. When you make a rule, the presumption is rules are prospective in operation.
May I submit my humble submission?
Look at, you are holding WPC OA 1030.
1201.
That's a writ appeal.
Prashant Kumar Behra.
Writ appeal.
Yes.
But you have the writ petition so that the page will match.
Writ petition is 1030.
Yes, you have that copy. Or you can look at in the paperless. Display besides you. Look at Annexure 3 in the writ petition.
Annexure 3.
If you have annexed the entire writ petition to the writ appeal, then you can get it also. Open the writ petition. 1030. That is dated 29/10/2008. Open Karantu. What's it please? The open WPC OA 1030. Open Kale. Go to page 10. Enlarge Karantu. Say it nahi. Dekha jivan. Outage chota Karantu. Scroll up. So last D sub D.
Contractual pharmacists who were engaged against contractual posts will be appointed after creation of regular posts. But in case of
mobile health units,
they will be appointed on regular basis in
Future
vacancies.
This is the 2008 rule. Therefore,
That also helps. Last paragraph.
Last paragraph, can you just find it? E. No, there is it probably.
This is the notification of 2008.
Just a resolution. It's a resolution. The pursuits of finance department circular. So,
not even this stands diluted.
actually,
It helps them is one thing.
MHU was not separated from this. They say that
As a techno-
while health unit and never treated them separately.
They are part of that only.
Annexure 3 million.
3. Last E. Paragraph E.
Contractual pharmacist who are engaged against a contractual post will be appointed after creation of regular post. But in case of mobile health unit,
Pharmacist.
they will be
appointed on regular basis.
In future vacancies.
So they are treated better than contractual. Normally, it will be contractual. For MHU pharmacist, it will be regular.
You will straightway, as against the accrual of the vacancies, straightway you will appoint them.
The reason could be 2002 and 2008, already 6 years completed.
Correct. And you needed their services. You were badly in need of their services. Otherwise, you would not have
Their
continued
service
them.
is inevitable. We cannot stand on the women.
Correct. And that's the reason we have made the deeming clause in that rule. Otherwise, they would have gone
So
out.
somebody working in MHU, mobile health unit, and working in the PHC, public health center, or CHC, community health center, can there be a difference in qualification? Because the duty is same, rather mobile is more onerous because they have to travel and do at remote
Same
location. Same job.
And they are on the scheme basis, because
That's the way of life. In several schemes of the Union of India, you are employing them. So that is how, in fact, you have protected them. Those who do not have qualification in 2015, still they will retire. They can work till their retirement. That exception, that is a exception.
And there is nothing in appeal. Even if we condone delay, being very magnanimous, after seeing your magnanimous argument, the very indigenous argument, still on merits you don't have case. But since you have argued all these things, all this will find place in the order, so that you should not deny relief to them on the contention which you advanced before us.
It's too late now. It's too late.
Otherwise, they will come here again.
And
that is not the object of law.
And as the Lordship said, what we are doing now.
That's what.
This proviso in Rule 4.
Yes.
Who do not meet the eligibility criteria as mentioned under Rule 5 shall continue as such.
It's a mandate.
Till closure of the project, retirement or disengagement, whichever is
earlier. Now all that will go. That will not apply to you because they are still there.
In some cases, suppose you disengage. Because there you can say that Amrit Kumar Misra will not come to their aid because they are disqualified. The proviso makes it
Yeah.
Because he justified all this. Now, since you have drawn the battle lines, we will treat the matter as battled. Simply, if you had said there is an order to pass order, consider this, we will consider, therefore dismiss our appeal, we would have understood. Now, you have given piece of your mind to us now, as to what you are going to do to these people. That will not permit.
No, man, just I am discharging my duty, keeping in view the records available.
This discussion has to be little discussion. That last paragraph.
companies also that they lack education as prescribed under Rule 5(2).
I thought there were no rules at all. As on the date they gained entry to the posts, so-called. That is sure. No, there were no rules. It was all under, because that resolution would have mentioned about the rules only. As you gained entry to the services, there were no promulgated rules. There were not. That is the reason now they have the 2019 rules. Do they refer to any other rules?
No, sir.
Thereafter also in 2020,
prospective, there is no point discussing.
another rules in there.
All those, these are all 309 proviso rules.
Yes.
Whether 309 provides for with retrospective effect, kindly see that. Kindly see, I do not know. I read the 30 the proviso long ago. Good to get the constitution. Because settled position is, unless the parent statutes give power to give effect to the retrospective promulgation.
Unless specified.
Unless it is specifically granted, conceded. You can't make rules with retrospective effect. Proviso to 309, because you are saying these rules are made under the proviso to 309 only. This gives legislative power also. Either they can pass a legislation, or without passing legislation, under the proviso only they can make the rules. That is, if the legislature makes a law, like Karnataka Civil Services Act 1978, we have, where section 3 or 4 provides the government can promulgate the rules with retrospective effect. Unless such a law is there, statute is there in your state, we can't travel to this one at all. As long as that, no, I have read that, yes. There is no such provision. The state could have legislated, the state could have made a Civil Services Act, providing that the government can make rules with retrospective effect. Then your argument would have held some water. But that question will not arise. Your rules do not say they are with retrospective effect. The presumption is any standard interpreters like J.P. Singh in India, Crawford in UK, many, they are there, Sutherland in US, all they say, this is a settled position. In fact, J.P. Singh has dedicated one whole chapter on that. All laws are presumed to come into force with prospective effect unless otherwise stated. Only exception is all procedural laws will come with retrospective effect unless otherwise said. These are the basics of interpretation.
Unless otherwise.
Unless otherwise. Procedural law.
Yes, sir.
The subjective law, all prospective, unless otherwise. Procedural law with retrospective effect, unless otherwise said. Then Article 20, Clause 2, no retrospectivity to criminal law. That question will not arise here.
Just have a look at last page of the book section.
Last one?
Last
SLP has been dismissed.
Yes. Relying on same Amit Mishra.
Last one.
Relying upon Amit Mishra.
Nothing has been brought before us to show that during the initial engagement of the pharmacists working in mobile health units under various community health centers, CHC.
Yes.
And the various, so that is a question mark, CHC question mark. So community health centers were not qualified to be engaged, as such. The Learned Council for Learned AGA as well as the Learned Council for the appearing parties also agree that in 2002, then there was no rule under the Article 309 as has been promulgated in 2019. The Learned AG argued WPC WA 1201 of 2022 as the lead case arising out of the challenging the order dated so and so passed by the learned single judge in WPC OA 1030 of 2012.
Dated 25/2.
The learned AGA relies on the order of the Supreme Court dated 12 January 2021, passed in special leave to appeal into bracket C into then number into bracket small s dot 13077 of 2020. The learned counsel, Mr. Samantray, appearing along with Mr. K.C. Sahoo for the respondent in WA 1323 of 2023, led the arguments. Raising a preliminary objection that the matter, at least on 2 occasions, regarding regularization of services of pharmacists working in mobile health unit has travelled to Supreme Court. That is once in Amit Kumar Misra, relied on by the state. The other being the state of Odisha versus Ashok Kumar Sahoo, SLP number into number dash of 2024 into square bracket diary number 16707 of 2020. The impugned judgment and order of the learned single judge was a direction to the state to consider the case of the petitioner therein in terms of the earlier order passed by this court, confirmed by the division bench, that WPC OAC you challenged in the appeal or single bench? You have not challenged that single bench. In terms of the earlier order passed by the single bench, dated?
Single bench dated.
No. I was right.
In terms of the earlier order passed by the
single bench dated 21/11/2019. Not by the single bench, by the division bench. By the division bench dated 21/11/2019. Passed in WPC number 3957 of 2019. Confirming the order dated 17/5/2018.
Made in OA 740.
Yes.
OA 740.
Passed by the Odisha Administrative Tribunal in OA number 744 of 2017. However,
notes. These are our notes for this one. Yes.
However, since there are several appeals arising out of similar orders passed by the learned single bench, and as agreed at the bar, the matter was taken up to be heard on merits regarding the contentions raised in the writ petition public WPC OAC on being transferred from the tribunal, as the case may be. it is contended by the learned AG that in view of the amendment brought to, in view of the introduction of the rule 2019, that is Orissa Pharmacist Service
Method of recruitment.
into bracket, methods of recruitment and conditions of service, bracket closed, rules, 2019.
The title is 1 kilometer long. Title of the rule is 1 kilometer long.
Don't make a mistake. The respondent is not eligible to be regularized. He refers to Rule 4, 5, and 10. Read with the schedule. To argue that since the recruitment was pursuant to a selection committee, which is not prescribed in the rule itself, their services cannot be regularized. Referring to Amit Kumar Misra,
Please be seated. Be seated. If we want, we'll ask you.
it is submitted that Amit Kumar Misra comes to aid of the state not to regularize the services of the respondents. Having gone through Amit Kumar Misra, we make the following observations. In Amit Kumar Misra, in State versus Amit Kumar Misra, into bracket Supra, State had challenged the order dated 3/2/2020 in WPC number 1353 of 2020. By the said order dated 3/2/2020, a single bench had directed to comply with the order passed by the tribunal.
We 744.
In OS 744 of
2017.
However, since contentions on behalf of the state regarding merits of the case were raised, apparently the apex court has gone into some detail in discussing the implications of Rule 2015.
19.
It's 2019.
19. They have wrong
So it's
written there,
the
2015. Yeah.
2000, should be right, 19? 2019, into bracket. Inadvertently mentioned as 2050. Textbook. Then you quote the pencil mark portion.
It's court judgment.
Relevant. Said, reproduce that because it's two pages. It's on the Supreme Court website, reproduce. For convenience of reference, the order is reproduced here. On perusal of the Supreme Court's order, the following facts emerge. The following facts and conclusions emerge. Roman 1, Amit Kumar Misra made the requirement to be selected and appointment as pharmacist. There is a deeming provision for regularizing the services of pharmacists under the provisions of Rule 4 of the 2019 rules. The contention of the state that the pharmacists who were appointed in MHU were to again go through a selection process was expressly rejected by the Supreme Court. It was held as per the deeming fiction, the employees who have completed 6 years of service shall be deemed to come into the cadre of pharmacist in the district
on regular basis.
We have the benefit of referring to the government order dated, government resolution dated 29/10/2008, issued by the government of Orissa Health and Family Welfare Department, into bracket Annex 3 to the WPC OA 1030. Paragraph E of the said resolution, by paragraph E of the said resolution, the government has ordered, quote E, the rest of the that's what you're getting your text exercise. Any other citations you want to relay?
Any citation?
I'm only relying upon that.
And so this is a unique case.
Yes.
Appeal has gone into merits.
Because we have gone into merit.
That also can dictate now. The reasons we are going for the appeal.
Ordinarily, since the learned single judge has directed consideration of case of the respondents herein for regularization in terms of Rule 4 of 2019 rules, we would not have much discussed the matter on merits. First one. However, learned AGA appearing for the appellant state vehemently took us through the merits of the matter as to the eligibility criteria such as qualification, etc., contending that the scheme of Rule 4 read with Rule 5, read with Rule 10, read with Schedule requires particular qualification and screening as well. First up, this we do not subscribe to because of clarification issued by the Apex Court in the penultimate paragraph of its order in Mishra's case. First up, we have taken precaution to ensure that the case of regularization shall not be, the benefit of regularization by virtue of deeming clause of Rule 4, 1 and 2 shall not be, only one, Rule 1, 4.1 shall not be denied to the respondents again by reinterpreting Rule 5.2, correct? 5.2 by the kind of interpretation which was sought to be placed before the Apex Court and which the Apex Court in so many words specifically rejected. Yes, dismissed. We are making elaborate order. The brother gave elaborate argument because you elaborately argued.
I'm sorry to point out now.
Yes.
4A1, not 4.1.
4A1. You can check that.
And so if you blindly don't go on typing, Supreme Court has said 9 to 15, so 19.
One sentence, just interpret, we can say.
Move your counsel, I'll make this good.
That's the sentence here. You argued excellent. It's a bad case for you.
It's my duty.
Heavily loaded against you by in terms of judgment of the apex court, even rule position.
And your approach also in on arguing on merits also helped us. Otherwise, again, there would have been some few more lines.
That side or this side?
We will say something on delay. We may condone the delay also.
In other ones,
that becomes another ground for them to go to apex court.
As may not be.
Yes, we feel that
The least delay is, I think, 120 days.
120 days, then 160.
That's what you said, 600 something.
Then it goes to the respondent.
120 days, 120 days delay usually.
What consolation my friend deserves.
But within what period you are going to do this? For that, again, one more case. Within what period all this will be done? That has to be specified.
Reasonable.
Now, reasonable is a chancellor's foot from 9 inches to 13 inches.
May I say 3 months?
Within 3 months. They will.
My lords may grace to extend the same. But I can fairly say that it should be not less than 3 months.
The order of the learned single judge shall be implemented, keeping in view our observations herein above, within an outer limit of 3 months.
But
if delay happens,
considering my concern.
No. We are saying, suppose if delay happens, what should happen? You will not do only. Because there are many of our orders which are not followed at all.
Reasonably, not
we are
later than 3 months.
No, 3 months we are giving you. That is the reason why they went in another writ petition. You did not implement it.
20 cases here, the list was here.
Yes.
But I'm not sure whether.
There are other matters.
20 cases, a list has been submitted. Can you see that?
200 cases.
So, Manti,
Same cases?
you've got the paperless.
I'm appearing in the third sub-item in this case.
So, please write in a piece of paper. Who is appearing in which one? And also look at this list.
Other similar matters, Manu.
Manti, look at the list.
List also.
Top of the brief, it is there.
All they have completed 6 years?
Yes, ma'am. Similar matters. They are not in the list. Not listed.
Not in the list.
Only 5 matters is in the board.
That one line is
Only 5 matters is in the board. But there is a list of around
this case.
Not listed today.
this
around 20 matters.
1030.
Around 20 minutes.
The respondent has completed 23 years from his date of initial engagement on so and so date.
All respondents have
May I submit something, Lord?
as of the date the rule came into force.
All respondents.
It's 1323. Lord, since we are the respondent. In 1030, I think there is no respondent. So 1323 maybe make the lead matters.
They are you are the respondent.
Yes,
in that.
In the other matter, there is no respondent.
You say, I mean, no, yet to be notice yet to be.
So I'm
In that we can.
In other words, when my learned friend is there, he is also the further respondent. In 1 to
1283,
814 also.
1030, the notice is yet to be.
814 also I'm appearing.
Wherever you are appearing, just give
Yes,
the
I have given on.
will mention. Whoever is appearing, just give that. In lead matter, in terms of that, all these appeals will go.
Yes.
yes.
Any employee has filed the appeal.
No.
No employee has filed the appeal. All right. So you have to answer our question. If within 3 months, we have fixed 3 months now, and that order is not complied, what should happen? Again, they should come to court to complain. No. It shall be complied, and compliance report shall be filed with the Registrar General of this court, Registrar Judicial of this court, within an outer limit of 3 months. That 3 months should come here. Failing which, what will happen?
It will be settled position whether I.
We will make it. We want to avoid further litigation.
I am tempted to say this because I am not very sure. I think there is no proper legal vetting also. The way the things have progressed, almost without any.
Absolutely non-application. Even rules are drafted mindlessly. But very fortunately, counsel said it to the Supreme Court itself. They are not happily worded.
This was happily worded.
It's not. Many of your rules are not happily worded. At least the 4 sets of rules I have seen.
After Supreme Court decided in that Amit Misra, there is no need of filing and keeping
all
these
these
matters
things.
pending also.
Troubling all these.
So you looked at the list, Mr. Manti. Top of the.
15 matters, my lord.
No.
So they will be listed tomorrow? Or within
Can I
next
have
week?
that listed if both of you agree? But other council will not be here.
Must be other councils.
Other council may be.
So that is, I was thinking, dispose it of today.
No, but
Then I realized that in one matter, as you pointed out, no notice has
no
been
notice
issued.
has been said. Therefore, with notice, let's say notice. That we can say.
If
deliberation.
at all, registry will be directed after completion of the same, then all other matters will be guided by the same and it will be listed at a bunch.
No, whatever matters are posted today, they have come to a logical conclusion now, today.
5 matters.
All right, 5 appeals are dismissed now. Now we are asking you, if you do not implement our order within 3 months, what we should do? You have to implement the order and report to the Registrar General. That we have implemented. We don't want to see their faces in the sense. We don't want them to come here again and stand here.
Well, this much will suffice.
Huh?
This much will
No,
suffice.
that solace is not
will come
sufficient.
prepared with a positive order.
No, again contempt petition. That we don't want.
Rounds of contempt ballots in this manner. First contempt, second contempt, third contempt.
No. So therefore, if if the compliance is not reported per day, 10,000 rupees. Yeah, that's the way. It is free. If you are going to comply with, even if we say that the concerned person should be hanged to the nearest tree in the court corridor, you need not worry because you are going to comply.
By virtue of the order of Honorable Apex Court, keeping in view the Amit Misra judgment,
Correct.
and that will be all the way taken care of by the judgment of my lords while dismissing this writ appeal.
Correct.
So, in my sense prevails that it will be done.
But that sense will not be there.
No. It will be happily worded by my lord. It will be happily worded by my lord. And definitely it will be carried out.
In the event compliance is not done, it is open to the respondent to move an appropriate application before this court for taking appropriate action against the officials concerned, which may include levy of heavy costs.
No, only they may.
We are giving liberty.
Only they may approach.
One application sufficient before us.
They may approach this honorable court by filing an appropriate
application.
That will suffice,
In these disposed of matters only.
Exactly.
No contempt, nothing. Yes.
That will be done.
Very good. Thank you. Now no costs. No costs. On delay.
Yes, on delay, it are dismissed, it appeal, and are remanded by our court for review. The matter on bail. Ask the registry to list all.
Yes. Registry to list all those.
All the matters as per the list provided in appeal 1323 of 2020.
Around 20 matters will not spend it. Here I have to serve a copy upon my learned friend who was entered appearance through cabinet.
Okay.
I'll serve it by tomorrow.
You give it. If he is ready right now, you have to argue because it is your appeal. You can't say he is not ready, therefore give me time. If he wants, we will give time to you. If you want time, we will give you.
Unless they have some copy, they are not some copy.
Now they are giving you. Give.
I only prefer next week, madam.
All right.
I'm out of employment, I can consider.
At the request of London Council appearing for the KVA, post this matter. Next week, we will not fix the date because next week it has to come. They have to.
Tomorrow I will serve it. The copy is served tomorrow.
Meanwhile,
madam,
copy of appeal book shall be served on London Council appearing for the KVA term. Yes, sir.
lordship. That is a state appeal where this whole question arises. Whether a benefit.
Delay by not that is 1,056 days.
How many days?
1,056 days.
Thousands now. You have got to thousands now. Like share market.
I have to submit on merit. Your lordship satisfied on merit, then your lordship.
No, we'll go to merit, provided the threshold bar you cross.
And I have also filed an objection to that.
You have filed objection. What is the reason shown to court?
But COVID periods will take around 5.
You wish COVID should have been longer. Mr. Panda, what is the explanation offered? When the government woke up from this slumber, that is the question. Presumption is government is sleeping. There is one famous book, Mr. Panda, maybe you have seen that. India grows during night. The author says during day, during night all politicians sleep and therefore India grows. That is a satire. That's how he has written that book. I don't agree with that. Not all politicians will sleep. Yes. What is the explanation?
We have already relied upon one judgment and said that
apex condition. What it said?
It says that the delay caused at the part of the government may be considered leniently because the government is an impersonal machinery and there is a not decision is not taken by one level, it's multi-level decision making process.
Then limitation clause will not apply to you at all. That way we have to interpret it.
No, if merit is there, substantial merit is there that to prevent gross illegality, lordship may condone the delay. The Honorable Great Court can condone the delay, thinking that the error may not be perpetuated. Only on that aspect, the lordship may kindly consider this application leniently and impose some reasonable cost we are prepared to compensate the respondents.
To accept rupees 10,000, let them pay 10,000 rupees to you. We'll condone delay. Then we'll hear after they make the payment.
Yes.
We'll hear that. This appeal is preferred after booking a very long period of 1,000 and odd days. First off, opponent state has filed an application supported by an affidavit seeking condonation of delay. First off, the State Council, Mr. Panda, vehemently argues that when a worthy appeal is brought on merits, ordinarily, delay should pale into insignificance, especially when the appeal is by the state. Since state has to act through men. And there are stages of operation also. First off, although this is not that happy an explanation for the delay, Learned Counsel representing the respondent very gracefully submits that some reasonable cost be awarded to his client and application for delay may be considered. First off, this is a tall stand which is really appreciable. First off, there are some arguable points in the appeal as well. First off, after all, howsoever longer the delay may be, its condonation would not add extra merits to the appeal to the disadvantage of the respondent. First, next, in the above circumstances, the subject application having been favored, delay of so and so many days is condoned subject to the condition that the state shall pay a sum of rupees 10,000 to the which respondent? Sole respondent.
Sole respondent.
To the sole respondent within a period of 2 weeks, reckoned from this day, failing which the application shall be deemed to have been rejected, and as a consequence, appeal as well. Okay. Both appeal also will go. 2 weeks granted, no, for making payment.
Fast matter. Fast over.
I'm
Holding that brief anymore, Madam.
You want time?
I'm no more holding that brief.
You are not holding the brief.
Brief has
When it was restored?
It was restored on 12/4/2024.
12/4/20.
March of year choice. Item 12. 10. Item 10.
When death occurred?
Death, your lordship, that is 2/12/2024.
And you have filed application on which date for bringing LRs?
Application that is 27/1/2025.
27.
27/1/2025.
27/1/25. So 90 days had expired.
Your lord.
So you have filed an application for setting aside abatement?
No, not 90 days. Your lordship, 2/12/2024.
12/24. Okay, so it is in time.
Your lordship.
In time.
In time.
Then no order is passed on that application.
No order has been passed. That's why it has been listed. Your lordship.
Right on. The sole appellant, having died on 2/12/2024, an application supported by an affidavit is filed under Order 22, Rule 4 here in Orissa, Rule 4, read with Section 151 of CPC 1908, seeking leave to bring LRs of the deceased on record. First off, these LRs are widow and?
Appellant number 1A2, 1C. The legal heirs of the deceased.
Who are they?
Their wife, son,
Widow?
daughter.
Widow and? She becomes widow after death.
Widow, 1A.
Widow as 1A, respond 1A,
And son,
and son,
1B.
respond 1B. First off, application is allowed,
And
the
daughter, your lordship, 1C.
and daughter 1C. Application is allowed, and petitioner, appellant is permitted, appellant or petitioner? Appellant is permitted to bring the LRs on record by loading their names to the cost title by appropriate amendment immediately. First,
So I'll consolidate cost title.
you want to file a, you have to amend and file this one. Both has to be done, not one cost title to be accordingly amended. And for the amended cost title typograph to be filed within 2 weeks. Post immediately after compliance. Okay.
So maybe
Yes. Yes, sir.
The order dated 29 for 2024. Thereafter, immediately I filed the appeal mine. But that was dismissed because non-removable defect by office. So,
For not complying with the office requirement.
meantime, some objection was there.
Yeah, you have filed application now.
That was
Allowed.
because their office said because of expiry of limitation, you file new case. So immediately file the new case.
You have filed new case.
And on merit, it is not maintainable. You will also see the input order.
Merit sir, my education of the execution case arising out of a GI case is pending before the education tribunal since 2013.
What is that?
The execution case no 108 of 2013.
Execution 108 of 2013.
Pending before the education tribunal, Bhuvan Sharma.
Educational tribunal. Educational appellate tribunal or a tribal education tribunal?
Tribunal.
It is there Education Act.
Education Act.
State Education Act.
Director's order.
Okay. So execution is pending.
Pending.
What is your grievance here? What is your grievance? Why what's your complaint?
The tribunal allowed my GI case granting some benefits to me, man. Because that was not complied since 2013, my lord. Till 2024, my lord, I filed the writ application for a direction to the educational to complete that education procedure.
Why are you saying that it's not maintainable? Take out Rahul Shah.
No, Lordship has see the impugned order para 3. Seems for implementation of the order and execution is already pending before the tribunal. This court is not inclined to entertain it.
That's wrong. That's wrong. Apex Court said in Rahul Shah, take out 2022 or 2021, 22. Take out, Google out that judgment. Rahul Shah versus so and so. All execution should be completed within 1 year. Incidentally, I was the author of that judgment in Karnataka. It went to Supreme Court. Google out. No Google experts in the court.
There also I have got a judgment by the Supreme Court that is CA number 364025, disposal 26325.
It is name of the case.
The name is Perimal versus B. Radman. Then
Perumal versus B. Raghavan.
Again. There is page 75, their lordship says.
Take out this judgment, latest judgment it is, 2020.
Rahul Shah versus Janendra Kumar Gandhi.
Correct.
22nd April to 2021.
Correct. 2021. Read in that paragraph. They refer to that was my judgment which went in appeal to the Supreme Court.
Apparently, during the pendency of execution proceeding before the trial court, the vendors again sold the properties in favor of Sri B. Premchand.
No, there they have said all execution should be completed within 1 year.
Concluding paragraph.
Because in Raja of Manda, the pre-council said in 1871-72 that the true difficulty of an Indian litigant begins after obtaining the decision. Execution is a headache.
The last paragraph, Lord.
Yes. Read.
We further direct all the high courts to reconsider and update all the rules relating to the execution of decrees under exercise of its power under Article 227 of the Constitution of India and Section 122 of CPC within 1 year of the date of this order.
Yes. that is circulated that way. This is deemed to be a decree. There is another judgment of the apex court in Tangabalu versus State of Tamil Nadu. It said all orders passed by education appellate tribunals or decrees. Well, of course, that was with reference to the Tamil Nadu Education Act. Anyway, this appellant is grieving before the grieving in this intra-court appeal against the order of the learned single judge who has dismissed his WP number so and so as being not maintainable. First off, the grievance of the appellant before the learned single judge was as to the dragging on of pending execution proceedings in execution case number 108 of 2013, pending on the file of education tribunal at Bhubaneswar. First off. Next paragraph. Learned counsel appearing for the appellant submits that in view of decision of the apex court in Rahul Shah versus so and so Gandhi 2021, which is the
Reference is not here below, but
it's there. Reference is there. Just any students of law just can find out that judgment. You cannot sit in the court all free. There will be some burden on you as a ticket to entry.
Well, 2001 volume 6 is
correct.
418.
2020?
21.
Correct. Thank you. What's your name? Very good. Thank you. Write down and give that. So yes. What you have done? What you have written?
6 SCC.
6 SCC. Page
418.
418 has said that the execution proceedings cannot be kept lingering indefinitely. First up, the fruits of successful litigation should reach the hands of litigants within a reasonable time. Right. First up, after all, right to speedy remedy is recognized as a facet of Article 21. First up, the speedy remedy includes the execution proceedings as well. First up, the impugned order of the learned single judge is not animated by this important premise and therefore is flawsome. First up, in the above circumstances, this appeal is allowed and the order of the learned single judge, impugned order of the learned single judge is set at naught. Semicolon. A writ of the petition, WP number so and so is allowed, favored, and a writ of mandamus issues to the education tribunal at Bhubaneswar to hear and dispose of the subject case in execution case number 108 of 2013 within an outer limit of 6 months and report compliance. Dispose of and report compliance to the Registrar General of this court within 6 months. First one, non-compliance may result into an adverse entry being made in the service register of the presiding officer of the tribunal. Months from the day a copy of this order is handed to him. Yes, within 6 months. Yes.
Item 19 minutes is a state appeal before Lordship. Having a delay of 123 days, Lord. 123 delay there.
123 days.
120.
He'll allow the application.
Oh,
State appeal, state intra-court appeal is filed after booking a delay of
123 days.
23 days. First of all, an application supported by the affidavit is moved, seeking its condonation. First off, delay is short and no objections are filed to the subject application. First off, even otherwise, there are some arguable points in the main matter. First off, in view of the above, application having been favored, delay is controlled.
I have felt the intervention petition this may be allowed.
You are intervener.
Yes.
Are you a party or just intervener?
No, just intervener, and we are only covered under their judgment, not only single just judgment. So we have to intervene in this case because we have to seek same benefit, but they filed the writ appeal. That's why
When they have not challenged,
Your appeal is not put in charge. Your matter is not put in charge.
But we have to intervene in this case.
On what ground?
Because we are the similar footing and similar employee, and we are getting the same benefit. But because of the filing this writ appeal, the government is not doing and not regularizing our case. That's why we have to intervene in this case.
You have obtained an order in your favor.
Yes, my lord. Yes, my lord.
That is not put in appeal.
Yes, my lord. No.
Then what is if they put in appeal, you challenge it?
please make also concerns that suppose the writ is allowed and intervene, that will be pending on him.
No.
Maybe.
Apex court said an intervener can only assist the court and he is not bound by the.
Yes, my lord. Yes, my lord. That may be allowed, my lord. Yes, that may be allowed. We can assist you.
Run the risk.
What my brother is indicating is.
We can assist you.
No, what assistance? So why do you think that
Let them survive on their own. The case survive on their own. Why you are taking a risk?
Not only that, you can't intervene. It is they decide. You are not before this court.
They were not in the original proceeding.
Tomorrow, court will be flooded with such applications. Good. An application is moved seeking intervention as intervener, as distinguished from party to the proceeding. First off, it is admitted at the bar that the intending intervener has got an order in his favor at the hands of the learned single judge in his case, which is said to be similar to the one involved in this appeal. First off, that is a very poor ground for seeking intervention. First off, the petitioner, the applicant does not fit into the contours of the ratio of the apex court in Rajia Begum versus Shahnaz Begum, AR 1958 Supreme Court page number so and so. Either as a party, a necessary party, or a proper party, or otherwise having locus. First up, in view of the above, the application is rejected. Okay. Yes, what is your matter?
Is matter,
Take out the
illegal appointments.
58 Supreme Court.
Some other day will have to work. Right.
If you are ready, we will hear you. What is the
Yes, we are ready. We are ready. Because, my lord, we have challenged on the premises that illegal appointments have been made, perpetuated by the order, citing an example that other similarly situated one person who was illegally appointed has been regularized. My lord, the rejection order, the impugned rejection order of the state was on the point that there is no concept of negative equality under Article 14. So one person who has got an illegal order, citing that example, they are coming.
That illegal order was made when, by whom?
By a person who was not competent.
Who made that illegal order?
That
what is its designation?
Designation, my lord. The impugned order in the writ application that annexed.
No, not that. You are saying that some illegal order is made by your employee.
Sri K.C. Guru, ex-inspector of schools, Sambalpur Circle, Sambalpur, has issued appointment order in respect of the petitioner for which he is not the competent authority to do so. Since the appointment of the petitioner was issued without jurisdiction and without following the rules, it is liable for the appointment was liable for termination. The appointments have been made without recommendation of circle section committee.
What action you have taken against that employee?
He is under you.
My lord.
What action you have taken? When he made that order?
Guru was removed from service. Don't know whether he subsequently challenged them.
My lord.
Sambalpur Guru.
Yes. So that was a scam, my lord. It was a scam, excess
So
appointment.
Swami might have defended his when he was in.
My lord, there was an excess of appointment beyond the jurisdiction.
59 SCL.
Huh. 58 AR, but 59 SCR. Yeah, sorry.
Yes. Yes.
What is page number? These page numbers differ from report to report. One of the famous judgments.
58 Supreme Court 886.
58 Supreme Court 886. AR 58 1958 Supreme Court 886. Whenever I say 58 means 1958. Okay? That way. Yes. That requires consideration.
Yes.
Yes, brother, requires consideration.
Because my lord,
Who are you?
because I am also opposite party.
You are also a party?
Yes.
Okay.
Only because the similarly situated persons have been regularized and discrimination has been done in favor of us because this illegality has been substituted by irregularity by the competent authority. Your Lordship, only will file the affidavit in this regard. Only for a moment, Your Lordship, see that illegality.
Sir, kindly just stop for a moment. Who made it illegality made regular?
How
What is
illegal?
government?
How?
How can it?
This is that, Your Lordship, see.
But binding on the court. But difficulty would be that is not binding on the court. But you don't dispute that you are appointed by Mr. Guru.
No. We are coming under that. But illegality.
1 second. Slowly we'll go. But do you dispute?
Yes.
Do you dispute that you are appointed by Mr. Guru?
Irregularity. There is a
We are
irregularity.
asking a question.
Yes.
If you don't want to answer, no problem.
Yes.
We don't compel you to answer.
Yes.
We'll have our own answer
No.
to our own question, which will be addressed to you.
Yes.
Yes. We are asking you, are you appointed by Mr. Guru or not?
Yes.
You are.
Yes.
Whether Guru has got competence to make such appointment.
Yes.
Show that rule. Show that. Demonstrate that. We'll dismiss that appeal right now.
The government also will the only support. They did the DI of school, did the inspector of school, the circle inspector of school is the competent authority to give the appointment, and that is the assistant.
That rule, notification, circular, something you have to say. Nobody can assume in a governmental process.
Then just without interrupting him, just be patient to hear how the matter proceeds.
Government cannot control.
Yes, government cannot control, but presume that it is their appeal. You should be patient. You should be wise enough to be patient in responding when your turn comes.
Yes.
So kindly sit down. Don't interrupt.
We'll help you. So wait. If there is merit, we'll give you order.
Yes.
If there is no merit, we cannot help.
Yes.
Yes, brother. Who is the competent authority? We are asking you two questions. When Guru made this appointment, which
of gurus?
appointed
Teachers are gurus.
Oh, that way Guru.
So he is a his title is Guru.
Okay.
Personal title is Guru.
So he appointed these gurus. In fact, there is a famous statement by Niraj Chaudhary, the famous author of Clive of India. He says, when true India
Sanskrit is Guru.
Of course, Sanskrit Guru is a famous shloka which says, Adi Shankar. Guru Brahma, Guru Vishnu. No.
No, there was a rule governing the field and there was an infraction of rule.
Which is that rule?
That rule is Odisha Education OEE Method of Recruitment and Condition of Service of Teachers and Officers Rules 1997.
Have you annexed that? Or from the book you are referring?
Only from the impugned order I'm just referring. The impugned order is at Annex 5 at page 1.
Education manual current.
In 97 rules.
97 rules.
Odisha?
Odisha education.
Odisha.
97 rules.
Elementary education, method of recruitment and condition of service.
Method of recruitment and condition of service of teachers and officers.
Rules 97.
97.
I have 2 zeros.
Why your rules are having such long titles? Generally, the best authors on legislative drafting, like Attrey, they say title should be short because long titles give room for doubts. 97 rule. No, this is UGC.
I have 2 zeros.
The main point is that
Just give us a
just get that.
Main point is rule position. Who is the appointing authority under these rules?
The Circle Selection Committee. The appointments have been made without recommendation of Circle Selection Committee.
Which says, which rule? Which committee means the selection committee constituted rule 5. There shall be constituted 3 types of selection committees to select candidates for appointment to various categories of posts of the service that mentioned each. There shall be what? This is what level committee?
It's a district.
District level. District level committee. Rule 5.3. Rule 5.3, Mr. Panda.
He's not having the book.
Exactly, it is not reflected below.
Take our one book, we'll lend you. We'll lend you one book, we shall share.
The narration of that job is, the designation is level 1.
One more date, your lordship, the grant I will come exactly.
The point appears to be simple. Up to a particular point where what
when there was a ban period, the appointment is 1 bed. There was a clear ban period.
Two things. Number one, the person who appointed did not have competence.
No. Having competence but violated the rules. During ban period, he had no competence.
Ban is issued under which section?
My lord, I'll satisfy your lordship. Give lordship has granted me one more chance. Just I'll come prepared.
Yeah. Can we take this matter day after?
Day after? Yes.
Call day after. Because our memory may
day
away.
Yeah.
How many appointments made?
My lord, the 1600 were to be here, 1800 something, 200 something more appointments have been made. Illegal appointments.
By that person?
By that person. It's a scam.
So now they are saying that some of them have been regularized. How many you have regularized out of
that? That I will come prepared.
Under Supreme Court set aside and West Bengal matter.
West Bengal matter, 27,000 people.
27,000.
Get the 2024 Supreme Court judgment. West Bengal. Teachers appointment scam.
Yes, teachers appointment.
These are also teachers only.
Yes.
No. You also just look into that judgment. Okay? Where large scale scam happens, apex court say it has set aside all appointments. Subsequently, a review petition was filed and some review order is also made. Just look into. We're already working for some 5 years or something like that. They were allowed to continue.
This matter Monday will not.
Monday? All right, all right. Next week you can put it something. You have to tell us.
Yes. Yes.
Where is the power to the government to ban the appointments? Because there is one judgment which says all appointments should be done periodically. Otherwise, many people will become age barred. Okay? That also you have to keep in mind.
State appeal will involving a delay of 185 days.
Mr. Panda, how many colleagues you have got here, government side?
How many, madam?
How many government advocates are here?
In this court will
Four advocates. Can you show one appeal which is filed without delay in at least 4 weeks? At least one appeal should be shown to us that you have filed appeal within period of limitation.
I will take a search in my office, then I'll come back. Come back tomorrow.
It was a satire to you. Yes. Sir, can you condone delay?
Yes, merit, on merit also is a case of regularization. From 95.
That at least will make an order for condonation of delay. Order we have given. One order we have condonation. Right now. A short delay of
185 person is 114 days. In my calculation, they have what the record is there 180 blank, but it is 114 days.
185 days. Report says wait. A delay of 185 days is proved in filing this appeal. Filing this appeal by the state. First up, an application supported by affidavit accompanies it. First up. Learned counsel for the respondent, standing tall at the bar, agrees with our suggestion that the application can be favorably considered. Since there are some arguable points, first up, in the above circumstances, application having been favored, delay is condoned. Ready or
ready?
Ready.
It's a case of regularization. Regularization of an employee who was serving in a establishment.
Consider for regularization or directed to regularize?
Direct.
Read the order.
Who direct to take appropriate step for regularization?
Yes.
Do you agree that it is a direction for consideration or it's a direction to regularize itself? If answer to the second is in the affirmative, then appeal requires consideration.
Yes.
If answer is in the first question is in the affirmative, then we will dismiss the appeal.
The wording is the appeal to is directed to take appropriate step for regularization of the services of the petitioner as against the post in which the petition is continuing since 14/7/95 within a period of suspension.
That virtually amounts to directing the authority to regularize. That the apex court said cannot be done. We can say that let them consider, we'll interpret that order as the one for direction to consider case of the respondent for regularization in accordance with.
In similar others have been regularized. Similar situation for some organization.
Therefore, they should consider who is the authority to appoint.
Earlier, we were already before the court.
Okay. Then he stands on a bit. Again and again, he cannot come here. Every time he will say, no, not possible to regularize. Every time he will come up with a petition. We have to spend all our time instead of diverting that to the other worthy causes. Other persons are regularized. Are they regularized?
Well, our ground is that one illegal appointment, Lord. Illegal appointment, and that has been continued by the order of the court. Because when regular vacancy will arise, he is to apply for the said post and his case is to be considered. that occasion never did not come.
How many years of service he has put?
30 years.
30.
30.
You mean to say that he will live for 100 years?
No. We are not saying so. He may continue that. Because of the court order, he is continuing.
No, for 30 years you have continued.
30 years he has continued.
Now, why did you continue if there was no vacancy?
No, we are not saying so. As per the honorable, because we did not challenge that order of the court.
Then you are at fault.
We acquiesced the order of the court that he is to continue, and whenever vacant, we both have acquiesced that order.
Whenever vacancy arose,
he will apply for regularization, and but vacancy never arose. That contingency never came. He could not apply for a regular appointment, and that continued. That irregularity continued.
In the meanwhile, have you regularized the services of anyone?
That I am.
That you have to show. Whom they have regularized.
Yes. That from with a specific case.
Let us see. If you have regularized others,
yes,
then you cannot argue this.
In paragraph 8 of the writ petition, writ petition.
WP. Page number?
Page number 5 of the writ petition.
That becomes a running page in your appeal, Mr. Panda?
26, running page 26. Running page 26 of the appeal.
Appeal memo. Go to 26.
I'm giving the name one Sukanta Sahu. Sukant Chandras.
Okay.
$26, no, 1 to 26, no? This itself is 26.
26 of the appeal memo. Paragraph 8 of the writ petition. They have annexed the writ petition.
Yes.
26, written at the top. Writ petition खोलो तो नहीं. You have open writ petition, open writ appeal.
Writ appeal.
All right, writ petition page number?
Writ petition page number 5.
5.
Yes.
All right. 1 second. A copy of regular appointment, order number so and so, 97, respect of one Sukant Chandra Sahoo is filed here as an except for. Kindly show, Mr. He was appointed on which date? Sukant was appointed on which date? That was 18/12/97. You gained entry to the service which date?
14/7/95.
95.
Yes.
But these rules have come into force when? The rules relating to recruitment have been promulgated in which year? No rules, nothing.
Recruitment rules.
Which
ORV 79. Regulation of vacancy rule is older, earlier.
You were appointed in 95.
95. 14/7/95.
But a person who is appointed 2 years later, he has been granted. So that person was appointed which day?
It was regularized on 97.
Therefore, it must be before that only.
Before that, 90.
No, just we want to know whether at the time when this person was appointed, there was a vacancy. Well, what are your pleadings, Mr. Panda, in your objection statement? In your objections to the writ petition?
Objection.
What have you stated? Well, how you answered this point number 5? Petition paragraph 5, there is a specific government.
Yes.
How you have answered that? in your objection, in your counter. What is their answer, sir? In their
paragraph 14 of the counter. Paragraph 14 of the counter.
Page number?
Page
14 of.
20, yes, my lord. Page 20 of the writ petition, my lord.
20 of writ petition. Scroll to 20.
Paragraph 6A, page 6 of the internal page 6 of the counter.
Running page 42 of the appeal memo. Running page 42 of the appeal memo.
No, you got it. 50 much.
That in reply to paragraph 5 of the request, it is humbly submitted that Sukant Chandra Sahu was never engaged on daily wage basis. Rather, Sahu was appointed as watchman by the DIXIT Odisha, that is OP number 2, right, order number 6591, dated 18/12/27, against a regular sanctioned vacant post. Against a regular sanctioned vacant post, he was duly appointed.
He was not regularized. He was appointed.
He was appointed.
Not a case of regularization.
No, not a case of regularization. We have distinguished that. Against a regular sanction vacant, but in the instant case, the petitioner was engaged on ad hoc basis and continuing till date by virtue of the orders of the Honorable Tribunal. No ban on recruitment of watchman has been imposed by the government, and says Sahoo was engaged as watchman, whereas the petitioner was engaged as a peon on ad hoc basis without following recruitment procedure and reservation policy.
No, but he was appointed to the vacancy.
When there was no recruitment, even he was not recruited.
That's not it. Vacancy was available at least. In our case, there is no vacancy. Therefore, earlier order said, whenever vacancy arises, your case should be considered. They say vacancy has not arisen. Where have you stated vacancy has not arisen? In your objection statement? After the first round of litigation, no such vacancy arose in the cadre. Where have you stated? You should have given the vacancy position in your objection statement. From this block period, from this period to this period, page 5.
Paragraph 5 of the appeal memo at page 5.
Also counted.
Yes, also in the counter. They have quoted, my lord. But that order was passed in 2013. That order was passed in 2013.
That's right.
Despite vacancies, they didn't prefer to make recruitment by him. Oh, that was decided by this honorable court, my lord.
Kindly read page 5, paragraph 5, last 3 lines. Last paragraph we can read. However,
it need not be said that as on that the applicant is still continuing in service. He will be allowed to continue in terms and conditions on which he is continuing on temporary basis till the post
is filled up on regular basis.
Yes.
The regular basis means a regular recruitment notification has to be issued. The people have to be called from the market.
Yes.
Then you can also be one of the candidates. You will be given the age relaxation.
Despite vacancies existing, my lord.
How many vacancies have arisen? When? When vacancies have arisen?
Yes, I have.
Mr. Panda, when vacancies have arisen? You mean to say from 2013, nobody retired, nobody died, nobody resigned.
All the base level posts were abolished.
They were abolished. All posts were abolished.
Base level posts were abolished. That was as a policy matter.
When it was abolished?
But that plea has not been taken in the writ petition.
No, what you should take, that is your defense. Why should he plead your defense? You should have said all posts are abolished and therefore existing vacancies will go.
But we have said in the appeal.
Panda, these are all small matters. They should not consume more than 5 minutes. Just you have to make a small note. When appointed, whether vacancies arose or not, whether posts are abolished or not. If you say one sentence with material that posts are abolished, straight away we would have allowed the petition. Where have you taken up that contention before the learned single judge? You can't abolish posts by oral argument. You have to produce some material. You should say, give some credentials. This is the government order. This order abolishes the posts. Therefore, question of accruing vacancies will not arise.
What vacancies comes up, madam? Page 29, my very appointment order.
Your appointment order.
Yes, ma'am. Page 29 of appeal memo. My first appointment order. It is ordered 31st July 1999.
What it says?
Sri Baba son of Sanasas is clearly if appointed as peon temporarily on ad hoc basis against the vacant post in the scale of business.
You have to read next sentence also.
Vacant post.
Sponsored by the exchange. You are not reading.
Sanctioned by government from time to time for a period of 44 days. Then you will see the next page, my lord.
When was your case sponsored? From an office, exchange office.
Temporarily appointed against the vacant post.
Correct.
In a press club person, sir.
Till 44 days basis.
44 days.
Yes.
From time to time for a period of 44 days basis. Till the post is filled up in regular manner.
Yes.
By the sponsored candidate of employment exchange.
That persuaded the tribunal to pass the earlier order. That whenever there will be a race shall be conducted.
And allowed to continue, my lord. It was extended from time to time, my lord. In the next order also.
It's a vacant post only, Mr. Panda. It is not a vacancy arises may not be the correct position, although there is such an order as well. That may not be because he has been engaged against a permanent post only.
Lordship, kindly have a glance to page 47. The order denying the regularization, that is at annexure A/1 to our counter filed before the Honorable Single Judge, where, my lord, the authority has clearly demonstrated for what reason the appointment, the regularization is sought cannot be allowed.
What is the reason?
The reason is, my lord, that is a checklist for Lordship, page 48. For examination of regularization of his case has been considered. Examination of regularization of contractual employees. Types of contractual employees, 2 types.
We have to get there. You are leaving us behind.
Engaged in government establishment directly.
48. Checklist.
Yes.
48 phase compare.
Yes.
But he was appointed much before that. He was appointed in 1995.
95.
Against existing vacancy. How long you want to continue in that post till he is dead? You can't continue. See, you have seen what the apex court said subsequent to Uma Devi. There are 3 judgments. Kesari. Inamdar. In Kesari, Inamdar said, if the persons have gained entry to the post as against the existing vacancy and continued for long, and long has to be somewhere you have to draw the line. It cannot be 5 years, 3 years, 2 years. But here is a candidate.
30 years.
30 years. That means you need his services. Otherwise, you would have sent him home.
Yes.
So you cannot keep an employee under the Damocles sword for 30 years. That is prime of a man's life. 30 years is a man's fruitful life. In the evening, if you send him back, where he should go?
We are not going to terminate him.
Huh?
He is not facing any termination.
But he will not get terminal benefits at all because you continue in the status of irregular employee. For 30 years, we will not allow that. Where he should go? The job is the only source of livelihood. And you have seen what the apex court said in Olga Tellis versus Greater Bombay Corporation, 83, 84 Supreme Court, 82 or 83 Supreme Court. Taking away means of livelihood.
Article 21.
Correct. 21. It's not a case of 1 year, 2 years, 3 years, 5 years. 30 long years. Olga Tellis versus Greater Bombay Corporation. Taking away means of livelihood amounts to taking the life itself, therefore violative of Article 21. You have to regularize. There is nothing.
I have taken note of in the single bench order panel.
Olga Tellis is not.
ML case.
Kesari is not.
Yes. And also another Supreme Court decision, recent decision, in state of Gujarat versus Tulsi Bhai, Dhanji Bhai Patel, in paragraph, they have to.
Will not interfere. See how to do that. State is in intra-court appeal seeking to lay challenge to a learned single judge's judgment order dated so and so, whereby petition respondent's WP number so and so having been favored, a direction as under has been issued. Operative portion of that order. First order. Learned AGA Mr. Panda, appearing for the state, vehemently argues that a direction to regularize cannot be granted, and at the most, the learned single judge would have directed consideration of the case of the respondents for regularization. First off. Secondly, he submits that the question of regularizing the services of the respondent would arise only if a vacancy arises as against his engagement, and no vacancy having arisen, the learned single judge committed error. Please be seated. Be seated. Error in granting relief to the. Kindly be seated. Vasanto. Correct? Vasanto. Yeah. Lastly, he submits that the respondent was had obtained. That was before the That was before the tribunal. Had obtained an order before the Orissa Administrative Tribunal. Then Orissa Administrative Tribunal in OA number 12 into the 93. 12 into so. So, wherein the direction was to consider the case of a respondent if and when vacancy arises, semicolon. This order having been acquiesced by the respondent, his writ petition subsequently filed could not have been favored. First. Next paragraph. Per contra, learned counsel representing the respondent employee contends that per contra, the counsel representing the respondent employee makes a submission in justification of the impugned order and the reasons on which it has been constructed. First off, he adds that an employee working for 3 decades cannot be kept under a Damocles sword hanging on his head eternally. Semicolon. Semicolon. The appellant herein being state has to conduct itself as a model employer in the light of apex court decision in Singer from Assam. Not Hajarika versus state of Assam. Sciences. First up, all the contentions having been considered, learned single judge has granted relief to the poor employee, and therefore that should not be snatched away by the writ court, appellate court. So contending, he seeks dismissal of the appeal. First, having heard the learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the submission advanced on behalf of the respondent employee. First, it is on record that the respondent gained entry to the service way back in the year 1995, and that till now he has been rendering the service with the spotless records. First, it is not the case of the state that his services are unsatisfactory or that they are not required. First, Mr. Panda, on being specifically asked, stood tall at the bar and said that the services of the respondent would be continued till he attains the age of superannuation in the same status. First, when a person is permitted to work for long period, and 30 years being pretty long, it cannot be argued that the services are irregular and that the same cannot be regularized. First, the very appointment order of the respondent specifically states that he has been appointed against the existing vacancy in a sanctioned post for 47 days. 44. Initially for 44 days. And it went on and went on till completion of 3 decades. First up, learned single judge. Next point. Learned single judge has accorded relief to the respondent employee, keeping in view the decision of the apex court in ML Kesari, which carves out some exceptions to the general rule laid down in our state of Karnataka versus Umadevi. 2000 okay. First up, despite vociferous submissions, learned counsel Mr. Panda was not in a position to show what error has been committed in employing the ratio of ML Kesari to the case of respondent. First off, in the above circumstances, this appeal being devoid of merits is liable to be dismissed, and accordingly it is, courts having been reluctantly made easy. Yeah.
Maintain appeal for the appellants. Appearing for the appellants.
My lords, I am appearing for State Bank of India. My lords, I had already entered appearance and we have filed up par, but somehow my name is not reflected in the list. My lords, I also beg to say that we have also filed an appeal against the same order of the single judge.
Your appeal is also there?
Yes, my lords, only it is waiting.
Along with appeal number so and so. Give that number.
My lords, it's still a diary number. Or despite being filed on 11th of June, it is yet to be numbered.
What is the diary number?
Yes, my lords. It's D-WA/496 22 of 2025. My lords, I will put it in the chat box for the convenience of the court master.
Yes, they will just put it to.
So, my lords, it may come up at the end of the month sometime so that we are able to remove any defects and serve a copy.
Of this month?
Yes,
sir, I can't really say so, but there's only one thing what has happened is
no, but that appeal, are you there in opinion?
It's too old. when he comes.
So in July, nothing will happen to him.
Now, what has happened is that particular land now has been encroached and he's not able to take any.
Nothing will happen within 2 3 days, 2 3 weeks. Okay. Then the last week of July.
Last week.
Yes.
Oblige, my lords.
Yeah, please. Being filed by the Staff Selection Commission, the matter regarding selection of junior is.
Objection, it was listed day for yesterday. Lots of directors.
There's a limitation.
Limitation
If
of-
they want to file objection, limitation is 274 days.
For filing delay.
Delay.
Your appeal is filed with 270 days delay.
I mean, file objection, just to kindness of the ground. Then nothing has been spelled out.
All right, but you have seen, suppose if we disallow the appeal on the ground of delay alone, you have seen what the apex court has said in that matter. It will only take the matter to Delhi, and from there it will come again here. Years will be spent in that. Instead, we'll give some cost to you.
Yes, madam. Yes, but
pay some cost.
Yes.
Both the sides having argued the matter on the application for condonation of delay.
You also normally condone the delay if it is less than 300 days.
Yes. No, not 300 days. 100 days. Generally, if it is 100 days, we will not insist upon conditions at all.
I don't know things.
Both the sides argued the application for condonation of delay of 274 days. First off, apparently this delay is a bit longer than usual. First off, some explanation is offered in the application supported by the affidavit. First off, it is unjust to dismiss an appeal of the kind only on the ground of delay of this length. First off, justice of the case warrants that delay has to be condoned. Of course, subject to payment of a cost of ₹5,000 to the respondent.
Respondent number one.
First respondent.
First respondent.
Or who are other respondents?
Other states. Who is the
First
state?
respondent.
The proponent.
First respondent.
2000.
First off, accordingly, ordered accordingly. And application is disposed of. Amount to be paid within 2 weeks. First, post this matter for admission after payment receipt is vouched in the registry.
I will pay this first month.
Now, if you pay now only we do. And that's the condition. We cannot go for execution. If you pay,
Even how much time?
2 weeks we have given. How much time we want? 2 weeks. And that matter will come. This is for payment. If you make payment and vouch it, then matter will come.
Yeah, that officially have to pay 2 weeks time.
2 weeks time. Yes. By seeing this newspaper, people will think that I am a kept witness. And damages were awarded in Winfield, Jolovich on tort. Yes, sir. Yes, sir.
Here, the election of the present respondent as Sarpanch was questioned in an election petition. On the ground that she is unable to read and write Oriya.
That's a legal requirement.
Yes.
Legal requirement is she should be literate.
She should be able to read and write Oriya, that is in terms of the provisions of Section 11 of the Orissa Gram Panchayat Act.
Let us read that section.
Madam, notwithstanding anything contained in Section 9, no member of a Gram Panchayat shall be eligible to stand for election. One of the clause is if he is unable to read and write Oriya.
Read and write. Your client does not know.
No, not my client, the respondent.
Respondent does not know.
Yes.
Your petition is negative.
My petition is questioning her election.
That is negative. That is dismissed.
That has been allowed.
Huh?
Election was declared void.
By the district judge.
By
the
the
electoral tribunal here is the district court.
By the civil judge, junior division.
Civil judge, whatever.
That was dismissed. In appeal for the land district judge also, it was confirmed, thereby affirming the finding with regard to the fact that the respondent is unable to read and write Oriya. Now, in the writ petition that was filed before this noble court, the honorable single judge has been pleased to reverse the same, which is now in writ appeal.
How appeal is maintainable? How appeal is maintainable?
My appeal is maintainable. That has been held by this noble court, my lord, your lordship will see. But initially, in 2008, there is a full bench decision of this noble court where, my lord, question of maintainability of appeal against an order passed in under Order 43 Rule 1 was questioned. However, while deciding, the full bench reference this honorable court expanded the scope to hold as to whether
Supreme Court decisions.
I'll show to your lordship, referring to Supreme Court decisions also.
Supreme Court has said that these kind of appeals are not maintainable.
No, my lord, rather I would say honorable appeals court has said that these kind of appeals are maintainable.
Give that.
Show that Supreme Court.
I'll show to your lordship that has been referred to. I'll show to your lordship which has been referred to by this noble court in a division bench. May I just cite that decision?
No, the problem is that suppose a division bench is not taking note of the Supreme Court decision. Which
no, that has been
clear.
taken note of. Your lordship may kindly.
So straight away go to the Supreme Court decision.
I am showing that also. That is the decision of your lordship will see. I think that I have filed also before your lordship.
Subhash Chandra Biswal. Subhash Chandra Biswal judgment.
Yes, your lordship. Here the question was in the context of Gram Panchayat.
No, regarding maintainability, whether the division bench has said anything.
Yes, that was the question at page, your lordship will see. That is at page 4, paragraph 4, page 83, your lordship may kindly see. May I place it, my
Paragraph 4 of Biswal.
Subhash Chandra Biswal, absolutely.
It doesn't refer to the Supreme Court decision.
But I am also citing the Supreme Court decision that is in the case of.
There are two decisions. I think one by Justice Goel and or Justice Goel and other by Justice Deepak Mishra.
No, I am citing that decision of Honorable Justice Deepak Mishra. I think
the citation is
subject to correction. This is 2018 Supreme Court page 3912.
3912.
But there is another decision there, wherein this is 2000, rather this should be the decision. 2015 9 SCC page 1. I'm sorry, my lord, I stand for
2015 9 SCC.
my lord.
Arising from this state.
This is not exactly from this place. This is from Gujarat.
But all depend, see, right of appeal should arise under a statute. Do you agree with this? Right of appeal is creature of law. This is what we have been taught in the law school.
Absolutely, no dispute about that.
Which statute has created right of appeal? Intra-court appeal.
My intra-court appeal, there are 3 provisions.
Which are
the provisions are no appeal memo. I'll just show to your lordship the provisions. Yes. They are like this. I have indicated that in my appeal memo.
Appeal memo also.
That is clause 10 of the legislation constituting High Court of Orissa at Patna, read with Article 4 of the Odisha High Court Order 1948, and also Chapter 3, Rule 6 of the Rules of High Court of Orissa.
Where have you pleaded them?
Page 1 itself in the cost title. In the cost title, I have indicated your.
No. The script have you produced? No.
Script, my lord, I have. Rules of High Court of Orissa, High Court order is there, and just
Let us see.
rules review.
Which paragraph of letters patent will say that?
Letter patents, clause 10.
Clause 10. Kindly read.
Pardon, Your Lordship.
Kindly read. Kindly
Yes.
face it.
I am extremely sorry, my lord.
You have that one.
High Court rules.
এটা নাই, এটা ক্লজ 10 টা বোধহয় নথিব হাইকোর্ট রুলস আমি দেখিদেবি কিন্তু হাইকোর্ট অর্ডারটা আছে I'll just assist your lordship. Your lordship kindly দেখি First, your lordship, if your lordship permits, chapter 3, rule 6.
Page number? Same book.
Just
Same.
I extremely sorry for the inconvenience, my lord.
Okay.
Appeals to High Court under Article 4. My lord got it. It is in page 31. If it is in
31. Yes. The same module. Same.
Appeals to High Court under Article 4 of the Orissa High Court Order 1948, read with clause 10 of the letter patent constituting the High Court of Judicature at Patna from the judgment of a bench confirming the judgment of the lower court under section 98 of the Code of Civil Procedure shall be heard by a division bench consisting of at least 3 judges, including both or either of the judges of the bench from whose judgment the appeal is preferred, and if the judgment is one judge or a bench of 2 judges, it shall be heard by a bench consisting of at least 2 judges other than the judge from whose judgment the appeal is preferred. But it is only referring to clause 10 of the letter High Court order and clause 10 of the letter patent.
No, let us understand. Let us dissect this rule 6. Appeals to the High Court under Article 4 of the Orissa High Court order. Let us see under High Court, Orissa High Court order.
Yes.
That page, what is that page?
I'll just show it to you. This book is a little not familiar to me. I'm just showing it, man. Orissa High Court order. Back to that. Wait a market. Orissa High Court order. In fact, I must say, this was the question also that was posed when the matter was heard by the Honorable.
No, the consistent view of the apex court is unless the concerned state has made an enactment.
Well, Orissa High Court order is at page 156.
156. Which paragraph?
Clause 4.
The lordship is referring to state enactment, granting a statutory appeal in such orders.
I understand.
So
here we are only.
So which part of Jogendra Singh ji by the Honorable Justice
Seta in a different context, I'll assist your lordship.
No, they have culled out point-wise which are the orders where 227 is not maintainable.
Man, not exactly that. They have said in
just kindly find the paragraph.
I'll place that. May I just, with your lordship permission, place this clause 4, then I'll show
clause
that.
4. And
the concept there, I'll explain also what concept they have said. Clause 4. The High Court of Orissa shall have, in respect of the territories for the time being included in the province of Orissa, all such original, appellate and other jurisdiction as under the law in force immediately before the prescribed date exercisable in respect of said territories or any part thereof by the High Court in Patna. Then that is referred to clause 10. But the letter patent constituting High Court of Judicature at Patna.
Let us see clause 10.
Clause 10.
Well, your 4 says, if there was right of appeal to the Patna High Court, you will have right of appeal.
No, that is being, that was because initially we are also attached to Patna.
That's what.
It's only later on we have become
bifurcated from that now.
Clause 10, yes.
So, all such original appellate jurisdiction as under law in force immediately before the prescribed is accessible to respect said territory. It's 156. Whatever right of appeal you had in the Patna High Court, that right of appeal shall be available to you.
I beg to explain one more aspect which my my Lord Justice Honorable Justice Sahoo was asking me. So far as this Jogendra Singh ji case is concerned, man, they tried to define about things where Article 226 and 227 has been exercised and where only Article 227 has been exercised.
Correct.
They have been, the Honorable Appellate Court has been pleased to hold if an order by the Honorable Single Judge is in the nature of an order passed under Article 227, then no appeal lies to the Honorable Division Bench.
Correct.
Obliged man. Now, the other part they have said that if it is under Article 226 only, or maybe of 226 and 227, much obliged.
Yes.
Then, my Lord, appeal lies to the Honorable Division Bench. One more thing in the same breath I like to add is, they have said the order passed by election tribunals are amenable under Article 226. So therefore, that you will find
220 amenable under 226.
So if it is 226 and they have styled the writ petition before the Honorable Single Judge as 226 and 227. Again, let me add also, mere styling of the petition will not be relevant.
We have to see actually order passed by a single judge. So under which provision?
If your Lordship sees Jogendra Singh's case, I think if I'm correct, my Lord, I have given the copies of the judgments. Jogendra Singh good much before. If I'm not married, then I may be pardoned for that.
Before the learned civil judge, it was a writ petition referring to a particular provision in the statute.
No, it was under Article 226 and 227.
Since no appeal is per se, appeal is there against the judgment of the learned civil judge junior division or senior division.
No. Appeal was before your Lordship. Appeal lies under section 39. After exhaustion of the appeal.
Appeal before whom?
Before the learned district judge.
District judge. So district judge confirmed the election tribunal?
Absolutely. Then the matter was carried in.
It is 227 only is my view.
No, my
review.
Your Lordship will see. Only one thing I'm here assisting here. If it is not maintainable, not maintainable for her.
No,
I'm just assisting her.
Kindly just clarify again. Election tribunal is civil judge senior division.
Yes.
Junior division.
He may be civil judge junior division, but he is as per the statute on the Orissa Gram.
He is the election tribunal. He is the tribunal. Okay.
Yes.
So against him you filed before he set aside the election.
I didn't file. He set aside the election.
The winning candidate went to the district judge
in appeal.
Yes. 39 appeal or order it's FAO?
No, in the 39 appeal. 39 appeal.
So against 39 appeal you come to High Court. That you are saying
I didn't come to High Court.
C again comes. C comes. You say it is immaterial. Who comes? Correct. The party, one of the parties come to High Court.
Yes.
That you are saying is 226.
226. Why I'm saying paragraph 7 of Jogendra Singh's case. Your Lordship may kindly see.
No, para 7, not para 7 is the conclusion. Para 30, 31.
No, I know that.
Because factually, because the ratio is not the facts. The Jogendra Singh ratio will be where it is irrespective of fact, which has universal application. So where they conclude.
But I am only on the proposition concept they have said, referring to the.
No, that is not the conclusion of Jogendra Singh, that if a appeal is filed against the appellate order of the district judge, it has to be 226 when it is election petition.
I am not saying that. I am only saying.
That I understood from your solution.
Paragraph 7, they have said that while dealing with the scope of proceeding under Article 226 of the Constitution, observe that there can be no dispute that the orders of the election tribunals are subject to.
You are referring to SEC or AIR?
This is AIR. This is 2015 9 SEC page 1.
All right. Subject to
the supervisory jurisdiction of the High Court under Article 226, and a writ of certiorari under the article will be competent against the decisions of the election tribunals also. The court referred to this and other decision. This is the observation they quote by
3334. Let us go to 3334. Paragraph 33.
So,
yes,
just look at 5 and 6 of AIR.
5 and 6 also.
Just before that, but
yes,
with the context of 7, you can get it there.
Yes.
At this juncture.
Right. Yes, at this juncture, we are obliged to state that the conclusions have been referred by the High Court to cover all kinds of possibilities, but we are of the considered opinion that it may not be always possible to do so, and hence advertence in detail to the said conclusions is neither necessitous nor warranted.
So that is not the conclusion.
I am not saying that is a conclusion. That they are in paragraph 70. 7th bench decision of the Honorable Appeal Court has been referred to say that the order of election tribunals are amenable under Article 226. The reason for saying this to your Lordship is that this writ petition that was filed was amenable under 226 and the writ application.
Correct. That is the reason. The Supreme Court says the order of the election tribunal is amenable to 226. But here the challenge is to the order of the appellate order.
No, it is
so that is not there. So suppose original this order of the election tribunal by civil judge senior division is challenged instead of filing the appeal before the High Court, it will be 226 only. Otherwise, it's alternative remedy, 39 remedies available. So that is your submission also.
Now your Lordship will see the next page again. Now if your Lordship sees that is paragraph 7.
You find it in the writ petition. Joginder Singh ji? You said copy in writ appeal or writ petition. Where to find it?
In writ appeal, I think I filed all these.
Anyway, let us see. What 33, 34 of Joginder Singh will say?
Ma'am, then one more thing I was placing, may I place it, ma'am? Then I'll go to paragraph. Otherwise, I'll place paragraph 33, 34.
Whichever way is convenient to you.
Ma'am. Now here, again in page 15, the Honorable Appeal Court quotes the decision, again paragraph 20. We are of the opinion that the election tribunals are subject to superintendence of the...
With the citation. Please. I was asking.
Superintendence of the High Courts under Article 227 of the Constitution, and that superintendence is both judicial and administrative, and that was held by this court in so-and-so case, where it was observed that in respect of Article 227 went further than Article 224 of the Government of India Act 1955, under which the superintendence was purely administrative, and that it is restored the position under Section 107 of the Government of India Act. It may also be noted that while in a statutory under Article 226, the High Court can only annul the decision of the tribunal, it can under Article 227 do that and also issue further directions in the matter. We must accordingly hold that an application of the appellant for a writ of certiorari and for other relief was maintainable under Article 226 and 227 of the Constitution of India. Here, pausing for a moment, I beg to humbly submit.
Can we read 33 and 34 and then come back?
No. 34 and 34. Yes.
33 टा देखा?
Yeah. In Hon'Ble and Sons, the court found that a specific fact was not brought on record. The evasive replies were filed, which were wholly unconvincing. In that context, the Constitutional Bench, speaking through so-and-so, observed, it is needless to say that the adoption of such judicious devices is not calculated to produce a favorable impression in the mind of the court as to good faith of authorities concerned in the matter. We must also point out that when a superior court issues a rule on an application for certiorari, it is incumbent on the inferior court or the quasi-judicial body whom the rule is addressed to produce the entire records before the court along with the return is returned. The whole paper for which such rules were issued as did in present case before the High Court, which strongly advocate this appeal on the part of the official respondents to bypass the court. Then 34. In Udit Narayan Singh Malpaharia, as the facts would demonstrate, the counsel for the respondent therein raised a preliminary objection that the persons in whose favor the board decided the petition not being made parties before the High Court. Be it noted, in the said case, a country liquor shop was settling in favor of appellant dairy.
So, Mr. You are reading which paragraph?
30. Your Lordship said 33, 34.
No. 30. You start with
30. You
refer to ground.
No, I told him to agree with the 33. But 30, you please come to.
My 30. I have marked 30.
From the aforesaid pronouncement.
Yes, absolutely. From the aforesaid pronouncement, it is graphically clear that maintainability of a letter patent appeal would depend on the pleadings in the petition, nature and character of the order passed by the learned single judge, the type of direction issues regard being had to the judicial perspective.
Jurisdictional.
I'm so sorry.
No, please, don't be that.
In the constitutional context, barring the civil code. Yes.
Kindly read it slowly.
Yes.
Barring the civil code from which order as held by the three-judge bench in Radheshyam,
Yeah.
that a writ petition can lie only under 227 of the Constitution.
Yes.
So Radheshyam still holds. That was my lord's. My lord was asking you that only.
No, I'm not saying disputing that. Orders, but your lordship will read. I will humbly request your lordship may read this judgment as a whole. Because
No, definitely.
some of the paragraphs only dissected.
Some is a conclusion actually.
Because
30 is a conclusion. Then they go.
Because if I have placed my lord, I had placed before your lordship that paragraph.
Kindly complete 30. Kindly complete 30.
I'll complete 30, madam. I'll then come back. My lord, barring the civil code from which order as held by the three-judge bench in Radheshyam, that a writ petition can lie only under Article 227 of the Constitution. Orders from tribunals cannot always be regarded as for all purposes to be under Article 227 of the Constitution. Whether the learned single judge has exercised jurisdiction under Article 226 or under Article 227 or both, needless to emphasize, would depend upon various aspects that have been emphasized in the aforesaid authorities of this court. There can be orders by the learned single judge which can be construed as an order under both the articles in a composite manner, for they can coexist, coincide, and implicate. We reiterate, it would depend upon the nature, contour, and character of the order, and it will be.
So simply, we can't say, brother, it is like this. Law, it appears both mongoose and cobra are put into this judgment. In one paragraph, it says, if passed by the tribunal, then challenge should be deemed to be under 227, notwithstanding employment of 226 as an ornamental. Court has to examine what actually the learned single judge has considered. Whether it falls under 226, whether it 227 is not that important. You have to see the nature of the order passed by the learned single judge. Then form an opinion as to maintainability of appeal against the same order. This appears to be broadly the ratio decidendi of Jogendra Singh.
One more thing I humbly beg to add. What is a 226 and what is a 227 order has been also spelled out in paragraph. Paragraph 7.
6 you read. 7 also
7.
You read.
I beg to read it the
read.
Rest portion again. The rest portion says when the learned single judge only interferes with the order and set it aside, that will be a 226 order. If the learned single judge issues further direction, then it's a 227.
What takes the character of 227? What takes the character of 227?
When further directions are issued. If it is, may I just read it again?
For example, give one example.
And for example, here what has happened, here the court has only interfered, set aside.
Set aside.
No further direction. So my humble assumption will be this is a 226 order. That is what.
Mr. Misra, what was the court looking at?
Literacy, linguistic literacy of your client.
If I cross the barrier of maintainability, then your lordship will find the order of the honorable judge.
No, we have to see
that barrier.
No, not like that. Because of this, you have a very good case.
Yes.
But you will be weakening that case. Suppose we interfere because the single judge was looking at a judgment of the division bench, not a district judge in appeal.
Absolutely.
39 appeals correct for the single judge. So suppose the single judge says that I am exercising power under 226. I am sitting in single, and the assignment is mine. I will exercise my power under 226 by overriding an order under 39 appeal.
But one thing I wish to point out, two or three judgments of this noble court, matter pertaining to Gram Panchayats, have been pleased to hold that the readable is maintainable. Maybe I will add in the same breath the analysis part of it with regard to this.
Then what happened to Radheshyam?
Has not been made much. But the honorable division bench have been pleased to bring that the readable is maintainable. Pointed question with regard to maintainability was raised. So therefore, this needs to be thrust out. Because I have at least two decisions in my possession of Honorable Division Bench of Reasonable Court in the context of Gram Panchayat matters, holding that is writ appealment.
No, not Gram Panchayat matters. 39 appeals. The single judge, suppose, interferes in a 39 appeal. You see, the election tribunal is not the district judge.
I understand that.
Suppose the district judge is the election tribunal.
Yes.
Then this argument of 226 is very valid.
And whether that will make a distinction or not,
it has to make a distinction.
That is to change, because if your lordship sees Jila Parishad,
then Radhesam is on the, then my decision would be on the face of Radhesam upheld by subsequent decisions. And lordship view is in fact prior to one decision of Radhesam. So referring to that
Renuka versus Tamanna. Or Tamanna versus Renuka. Karnataka High Court. Same question arose before 5-judge bench of Karnataka High Court.
it was printed, sir.
They have printed.
Printed and you referred in some cases.
but just if your lordship pardons me, if your lordship has decided on such an issue, then
No,
our 5-judge bench of our High Court, Karnataka High Court, from where I hail, that had an occasion to consider all these arguments. And one of the judges, she has considered all aspects. Renuka versus Tamanna, or Tamanna versus Renuka, I don't remember correctly. 2009 ARSCC Karnataka, online.
they have been closed for all time. So this is just cropping up again and again.
That's true.
There are many petitions.
No, even Joginder Singh.
But the decisions you are citing, there are 2 High Court decisions, they say they are in context of 39 appeal. And they take them.
Or against the order of the tribunal.
And that was a.
But how that will be?
But they don't consider Radhesam.
There are many things.
There is one book, good book, by Justice B.L. Hansaria, Writ Jurisdiction.
Lordship is referring to that book, which was published
by Indian Law Institute. His son has revised it. His son has revised that. There is some reference to that.
When his lordship was here, I think he published that book, that Writ Jurisdiction.
Oh, I do not know.
Yes.
But it is published by Indian Law Institute.
In possession of that first book, that old book, not the subsequent one revised.
No, it's a very book, it's now treatise.
That was a little
B.L. Hansaria's son has revised.
Yes. I have that book, but
some
the first one.
Literature, some discussion has happened there also. But this question has been lingering in whether from intra-court appeal, wherever intra-court appeal is.
Here, it is also still not firmly decided. So I
finalized.
There has to be put an end to. Because either way, the party can also go to the next higher forum if it is not.
No, that will be very taxing to the litigant. Asking him to go to Supreme Court.
Many cannot have.
Almost this court becomes the Supreme Court.
It gets filtered. Maybe that 10%, 5%.
Therefore, that aspect also have to be kept in view.
Yes. There are various facets which is cropping up in my mind after deliberation. I'll also assist on that. There are many aspects, the nature of order.
Just look at 44 of what you are reading now. Joginder Singh.
Yes.
Para 44.
The Sanskrit it is called.
Your lordship is possibly referring to the conclusion part.
Only one principle does not emerge. Competing principles are emerging. As we go on reading, in Sanskrit literature, in logic, it is called the Eka Sutra Nirnaya, where only one principle emerges from a decision. We have no much difficulty at all. If various paragraphs, competing principles emerge, one principle silences another, then synthesis becomes very difficult. In fact, Rupert Cross, in Precedent in English Law, has discussed when the law-laying court tells one thing in one paragraph, another thing in another paragraph, how ratio decidendi of a decision can be churned out.
Very honestly, Joginder Singh's case, when I read, I totally got confused because I find different different connotations. So I had a lot of difficulty. But as a lawyer, I have to take advantage of the observation that has been made in my favor in the judgment.
That advice is not with the judges.
Because as a lawyer,
Rupert Cross on a Precedent in English Law, it's a very famous book.
So the
police
last
publication.
44, there cannot be the last conclusion.
Yes,
Just look at the conclusion. There cannot be a straitjacket formula for the same.
absolutely.
Needless to say, the High Court, while exercising jurisdiction under Article 227 of the Constitution, has to be guided by the parameters laid down by this court and some of the judgments that have been referred to in Radheshyam. And Radheshyam is upheld in also in Joginder Singh Ji. High Court acting in 227 means the single judge.
I have to
that is the difference.
One second. We need not go to discussion because kindly come to paragraph 45. In 45, they have summarized their conclusion.
And that I wanted to also place.
Yes, please. Let us see this summary.
Whether a later patent appeal would lie against the order passed by the land single judge that has travelled to him from the other tribunals or authorities would depend on many FSI. The court feel able on a petition to make it under Article 226 or 227 or both.
No, that may not be applicable to us because we are not on that.
That is one and same. So it will not be applicable.
45.2.
The order passed by the civil court is only amenable to be scrutinized by the High Court in exercise of jurisdiction under Article 227 of the Constitution of India, which is different from Article 226 of the Constitution of India. And as per pronouncement in Radheshyam, no read can be issued.
45.2.
2 is
against you.
2 is not against me because this is with regard to civil court. This is special tribunal under the Gram Panchayat Act.
No, see, you went to civil court. In appeal.
Read slowly.
Yes.
Against you.
In appeal.
The order passed by the civil court is only amenable to be scrutinized by the High Court in exercise of jurisdiction under Article 227 of the Constitution of India, which is different from Article 226 of the Constitution. And as for the pronouncement in Radheshyam, no read can be issued against order passed by the civil court, and therefore no letter patent appeal would be maintainable.
Now, the court which passed in your appeal, is it a civil court or persona designator? It's a civil court only.
I will say it's under a special statute.
No, but section says civil court.
39.
Kindly read section.
39.
It's a civil court. The first one is the tribunal.
It will not be a civil court for the reason your Lordship will see. Certain provisions will indicate that this is not being written in statute. I'll show to your Lordship those provisions.
Appeal lies to the civil court. That is district court. District court.
39.
Yes, it's a civil court.
In fact, if your Lordship sees the tenor of the statute, that is Orissa Gram Panchayat Act, it will indicate that certain provisions of the CPC have been made applicable, which itself presupposes that all the provisions are not made applicable and it has been treated as a special right.
1 second. 1 second. A civil court does not cease to be civil court because all the provisions of CPC are not made applicable.
No, I will not say that. I'll never say that.
Some provisions may not be applicable. For example, family court.
I'll never say.
No, we are telling you, family court.
Yes, ma'am.
Is it not a civil court? Family court is a civil court.
It's a civil
court. No, Evidence Act is not applicable. CPC may not be applicable.
Evidence
Act is a civil court.
Presently applicable, but true it is. Nothing to dispute about that.
Just look at 35.
Madam.
The initial petition before the civil court.
35 your Lordship is referring to.
Orissa Gram Panchayat Act 1960.
Yes. 35 may I place it, ma'am.
Just opening paragraph 1. Page 81. Subject to the provisions of this act, it reads.
Yes. The rules
made thereunder. Every election petition shall be tried by the Civil Judge Junior Division as nearly as may be in accordance with the procedure applicable under the Code of Civil Procedure.
Yes.
Then just kindly look at 37. Power of the Civil Judge Junior Division.
Yes, ma'am.
Power of a civil in a court under Civil Procedure Code.
This presupposes that the Civil Judge Junior Division is a tribunal under the statute is given a power of that of Code of Civil Procedure. Kindly see the language.
Otherwise, there was no need for such a provision at all, is your contention.
No, that's much of placement. That's what I get to say. Now, the Civil Judge Junior Division shall have the powers which are vested in a court under the Code of Civil Procedure when trying a suit, whatever is there.
So it is a tribunal.
That's what.
Otherwise, that section would not have said all powers will have, etc. Where is the need? If it is civil court, CPC is applicable.
Much obliged, man. That's what I beg to submit, man. And then the other part would come that if it is a tribunal, whether 226 or 227 in the view of the 7 bar.
No, they go to district judge.
Yes, appeal. I'll have to, my lord, also meet that point. My lord,
Appeal is section.
Just my lord, I'll just. Sorry, I'm sorry. 38. I am so sorry. It is 38 surplus 4. A person aggrieved by the lordship got it, page 85.
85. Yes. Any person aggrieved by an order of the civil judge junior division may
in the manner as may be prescribed before the district judge having jurisdiction, who shall have, so shall after giving party of giving heart, confirms the verse, and all those things. This is again not like an appeal under the CPC that way.
But there are judgments of the apex court where some other statute provides appeal to the civil courts.
Yes.
All powers, it will be treated as an appeal only.
That is true.
There are such judgments.
I have to also see that decision of your lordship, my lord.
No, not our High Court judge.
Yeah, 2009 Karnataka 119.
Correct. Year 2009. Karnataka 119.
119.
Yeah, Karnataka 119.
5 judgments.
No, two aspects. If we agree that your petition to the civil court, it's a petition. Correct. Even family court petition for divorce.
Petition.
They need not be plained. One by one we can go. Plaint is not defined. Plaint, the CPC section 25 says a suit is also not defined. Section 25 CPC says a suit is instituted by the presentation of the plaint.
Yes.
So this is not by presentation of the plaint, therefore it is not a suit.
Now here the
section itself says petition.
Yes, petition, but here also there is a provision how the petition is to be presented.
But no, in any way it is not a suit.
It is not a suit.
It's an appeal. Appeal.
It's appeal because
first one is petition.
First one is petition.
Yes.
First one is petition.
Then it's introduced by amendment. It was earlier final.
Second one is appeal.
Yes.
Appeal from the order. Civil judge does not pass the decree.
No.
Because there is no plaint. Because it is not a suit.
Absolutely.
So it is a petition.
Yes.
On petition he makes the order. That order is appealable under section 38(4).
Yes.
Because the terminology of that section, though the many rules I have been seeing, they are not that happily worded. In fact, Supreme Court itself said your rules are not happily worded, at least in 3 judgments. One we have seen today.
And the statute also here says that even civil judge order are orders, judgments,
not decrees.
Because that is subsection 338. It says all orders of the civil judge shall be subject to substitution. So that itself shows that these are orders, not judgments.
Correct.
As your lordship was pleased to observe.
No, whether it is judgment or order does not make much difference. Because appeal under CPC is against the decrees, not against the judgments.
Yes, absolutely.
All appeals are against decrees.
So the last part of the judgment can be treated as a decree where the decree has not been pronounced.
But that this is called as an order does not make much difference to our discussion because 104 of CPC read with order 43(1). All they are appealable orders only. And they are to the civil court. Therefore, that does not alter the position.
That the 100A will come into picture.
That's what.
Devarying an appeal.
Therefore, that does not add any jurisprudential quality or factor to our discussion. Question is, the district judge, is he, it is a district court, district judge functioning under 38(4) is a persona designator or he is a court? That is the question. If he is a court, then 227. The order passed by the judge will be 227. But see the extent of the power. What it says is, can confirm, reverse, alter, or modify the order of the civil judge. So this to paragraph 45(3).
And that
because one paragraph said you have to see the content of the order. Content of the order of the learned single judge in turn depends upon the content of the order of the district judge. Because orders which you are challenging, the challenged order will cast its shadow or light on the order of the single judge. That assumes significance because of observation made at para 7 of Joginder Singh.
And one more thing I'd like to humbly point out, here in subsection 4 of section 38, one more phraseology which needs to be noticed is that this appeal in such manner as may be prescribed before the district judge having jurisdiction. So that
no, prescribed by rules.
Yes.
Prescribed by rules.
Absolutely. So that phraseology is to be taken care of to contextually understand whether this is exercising as a civil court power or in the context of traveling from a tribunal to a appellate tribunal. That is to be seen. That is to
no, merely because by this phraseology, arguably, CPC provisions are excluded. That does not render the civil court no less a civil court.
That is to be seen. And whether, as your Lordship was pleased to observe, that whether a purposive interpretation can be made to save an appeal here. It is not meant.
Otherwise, it will be very difficult for the people to travel to Delhi all the way from.
Whether that purposive interpretation can be made or not, that is to be seen. Now, since we have, if your Lordship permits me, I'll, since at least the deliberation we have, I have learned a lot, my Lord, how to frame things.
We have learned from you also.
My Lord, if your Lordship grants little breathing time, I'll come back with all those decisions and we can have a final conclusion on the point.
Who appears for responding?
My friend.
You are appearing for respondent. What is your contribution to the discussion?
Well, let my learned, I have to learn from my senior. Let my learned senior complete thereafter. I will try to assist you.
A contributory proceeding.
But here,
that one will argue and discuss on law we are.
What I have heard from my the two judgments which my learned senior wants to point out of this honorable. There are two judgments of this honorable court does not deal with that aspect that the 39 order has been assailed on the petition or not.
What were the orders?
There, my lord, directly tribunal's order was assailed.
Even when 39(4) was available?
Yes. What had happened, my lord? There a maintenance petition under 711 was filed. The first judgment is that whether the judge...
It was not appealable at all?
No.
Against that order, matter went in writ petition.
My lord, your lordship, I kindly see one thing. I'm sorry.
Well, I have got the point now.
Here, your lordship, the presentation of the petition is to be before the learned civil judge junior division. There, the petition was presented before additional civil judge.
Therefore, 711 was moved.
711 was moved. This honorable said that no. So there, my lord, as my honorable Justice Sahoo had pointed out to my senior, 39.
Learned senior said that he will verify. Actually, he is not sure of that.
My lord just pointed out one thing, that 39 order when it is challenged, whether it is 226 or 227. So the judgments which to correction by my learned senior, one judgment I had seen, my lord, there a 711 was rejected. 711 was challenged in a writ petition. That was challenged in a appeal. So 39 consideration.
Final order was not put in challenge.
39 order was not challenged. Subject to what my learned senior assists your lordship.
Wouldn't be as a final order. Because so the interim 711 will be
but then On interim orders, writ appeals are maintainable. On final orders, writ appeals are not. That will be very illogical. On interim order.
So the other decision, other 1711. Achha, you have not checked. Okay.
That was with regard to a removal of that cost not paid defect.
Cost not paid.
No, that's why this question arises is Rupert Cross, a famous author on law of precedent, refers to Quinn versus Latham, 1901 judgment of Lord Halsbury. How you should take out the ratio decidendi of a decision. There are tests on that. Dr. Upendra Bakshi's test. There is a Professor Wamba's test, which jurisprudence by Samand will discuss how you are going to take the ratio decidendi of a judgment. To this, one more thing you have to add now. Because apex courts say Article 141 of the Constitution not founded on doctrine of precedent at all. Take out that judgment. Barkatullah versus Rudramurti. There are 3 judge bench of the Supreme Court. I do not know how far that is correct, but just see that. Rudramurti versus Barkatullah or Barkatullah versus Rudramurti. Chief Justice Rajendra Babu's judgment, heading the bench of 3. He says at paragraph 6, the Article 141 declaration of law is not founded on the doctrine of precedent at all. So if that is so, what the apex court says becomes law, not because it has changed value or not, but because it is so declared by the apex court. There is such a judgment. ILR 90 is...
I am not ready, sir.
No, that 2004. There is such a judgment.
Ratio decidendi, as we understand, is fact and law turned out the product is ratio.
But 141 is not dependent upon ratio decidendi. That doctrine at all. If that is so, then how we should see? Is it a declaration of law by the apex court? While interpreting construing the judgment, and the judgment, various paragraphs there, some paragraphs compete with each other.
Yes.
We don't say conflict with each other. At least the content and intent of some paragraph compete with each other. Therefore, just examine all these aspects and come back. Look into B.L. Hansarai's writ jurisdiction. Some arguable point is there, which in his very unique style, very impressive style, he has put forth. We will also read. Every day, reading from my series. You read every day. We read. We learn by case to case basis. Some date we will fix. We'll also look into it and come back. We'll also study and come back. That 2019 ILR. So we have given you list of the judgments now. You note down. You have to make notes and come back.
I'll give you.
You just write down.
That 2019 ILR, which my lord has, that is
2000.
That 711 application was done.
AR 2009 Karnataka, page number
119. That I have noted.
Kamanna versus Renuka, number 1.
And I have not.
Because this matter is discussed in detail. Number 2, Quinn versus Latham. QUINN LEATHAM. 1901 House of Laws. Okay, how a judgment should be construed.
In All England Law Reports, it is page 7.
Page 7.
1900 All England Law Reports, page 7. Or appeal cases, 1901.
91.
I will get it from Honorable.
So when my senior asked me, Mr. Vikramante has all the appeal cases.
AC.
My lord also used to. We had a old judges library. We had a old judges library. My lord, during his lawyership, we used to see on a table. There was only one table. Now it has been modified and study there whenever he has free time. My Justice M.M. mess out. I remember those golden days.
I feel very small compared to his lordship's last time. You see,
I learn every day so much.
I don't remember the contents, but he remembered the contents, page, line, paragraph.
But we remember then also my lord's methodicity and meticulousness.
That's
then
what-
also. And one interesting aspect is each and every Advocate General was interested to keep him with him because of that matter.
And third judgment is Barkatullah versus Rudramurti.
That I have noted.
I have noted that matter. Then Rupert Cross, President in English Law, very small book.
Yes.
Very beautifully has given how of their judgment should be churned out. Okay?
So great.
It's equivalent, I will tell you. There is President in Indian Law by Professor Lakshmi Kanta. He has also given second edition. Just look it.
Malad, may I make? Item number 42. This is a wife searching only for quantum. 3 lakhs has been awarded. If there is a female child, she has not got.
When do you want?
Malad, can it be Monday, my lord? If I don't.
Monday you have several matters.
Many matters.
So I mean, it's maybe on 16th.
Malad, there's a
Maybe
application
16.
for orders because I applied under RTI from Fit University. They refused, said that will not provide. So I filed a mistake, let it come for orders, my lord.
Any week after next, some days we can accommodate. Right? Look,
For orders,
clustering should not happen.
42. For orders, your lordship, then.
I want to make a mention, Lord, item 45.
Oh, yes, finally, I
Appeal by wife against the order of divorce. Lord. The wife and husband both were directed to appear before this order.
They are here.
This has come.
wherever there is a personal reference, just mention. Should mention. Because we are not aware actually.
No, only.
Because at times it is not marked at 2 p.m. So if you mention, then
Wife has come, but the respondent husband has not come. Maybe tomorrow, Lordship, the husband will come.
Who will? Wife has come from which place?
He's from both. 400.
How many kilometers? How many kilometers?
400 around 400.
Give 1,000 rupees to the wife. Call this matter tomorrow. Tomorrow. The respondent husband is directed to pay cost of rupees 1,000 to the wife, who has come all the pursuant to order of this court and present before the court. But tomorrow you should pay 1,000 rupees. Otherwise, we may strike off your defense.
item 45.
Non-payment may result into striking off the defense of the respondent husband.
Madam.